Okay, two prayers lordship. With item number 36 lordship, we have filed an affidavit in reply lordship. That will be called for.
Okay.
Lordship, another prayer lordship, can this matter be taken up at 2 your lordship? It has been taken up at 2 all this while your
Which
the
one?
last order it was not reflected.
36.
36. Sir.
Right.
Otherwise, the matter was almost completed, lordship. Only our reply is there.
There's
Respondents.
no reply. You have made your arguments. Why you are filing an affidavit at this hour?
Reply because lordship.
Who has asked you to file an affidavit?
No, still they filed the affidavit lordship.
When the
after-
matter has been heard out there, hearing is going on, and then in the midst of that, without taking the leave of the court, how are you filing an affidavit?
It's a reply against an affidavit in opposition.
So what? First and foremost, you should have taken the leave of the court to file it. We have already heard the matter in the entirety, and then you are now coming up and saying that you want to file, you have filed an affidavit. Why should I call for it?
Also, because in the last the lordship wanted to know whether an FIR has been filed or not, lordship, against the alleged alleged against the alleged action of the respondent authorities, your lordship, in converting their bank accounts from the Bhini Gugoi, the other respondents to that.
You have filed a file.
We have filed an FIR.
Then what happened?
We have filed them.
I don't-
Lordship at 2 year long.
Now,
I have to call my senior.
of course, you're seeing it.
The reply will be called for.
Take it as the last item of the day. Order key? Yes.
Doesn't matter where it step tomorrow. Well, I have filed the case, my lord, and there is filing number also. Maybe listed on tomorrow, well, for motion, my lord.
Why?
Since urgent, my lord, settlement of a market, my lord, issuance of shares, issuance of tender, my lord.
Settlement of market?
Yes,
Panchayat?
yes, ma'am.
First of all, you go to bench 4 and mention. Not here.
4 months, this is 4 months.
I'm 4-5. Mention only where it is 4.
Lordship, in item number 17, we have filed an affidavit.
What is it, Mr. Sen?
This is for restoration of the restitution which was dismissed for non-restitution without. At page 3, paragraph number 2, my lord, and 3. For the reason, my lord, we have cited.
What is your reason?
May I read, my lord?
No, you can say.
My lord, due to oversight in the daily police, my lord, the learned engaged counsel could not appear in this case when the matter was called for.
Heard Mr. P.K. Sen, the legal counsel, appearing on behalf of the petitioner. So this is an application filed for restoration of the petition which was dismissed for default by an order dated 25/4/2025. The court have duly perused the reasons assigned in the application and more particularly at paragraph number 2 and 3. And the court is satisfied that there were grounds for which the petitioner counsel was not present on 25/4/2025. Accordingly, the instant application is allowed, thereby restoring the petition being WBC number 1368 only 2025 to the file of the spot. I explain the spot. Okay, now argue. Main pattern.
The main petition, my lord.
Let's come up for motion. Let us see what is your case.
Orders, my lord.
What do you want? You have legal services.
No, my lord.
What is
My
this
lord,
case?
in this case, what
Running
has
a
happened?
cloth business including selling of sari and ready-made in the thereafter insurance with the Oriental. Insurance company under the Oriental to the prisoner. Insurance company to the fees. No, here, Mr. Counsel,
My
tell
lord.
me, how can this go? Side of the quantum.
Landed ombudsman, my lord, without considering the materials and my lord, the hearing the.
No,
petition.
understand everything,
My
but
lord.
how can this court go into the question of
No,
quantum?
no. My lord, your lordship
This
only.
court could have
only-
very well gone into that you are entitled or not.
That part, my lord, ombudsman will decide. Your lordship will only see whether, my lord, the order passed by the landed ombudsman is correct or in
Where,
accordance with the
where
law.
the order passed by the
My
ombudsman,
lord, page 35,
page,
page 35 is the into order. My respectful submission, my lord, lordship will set aside this order, my lord. Demand back to the matter before the landed ombudsman for re-hearing after hearing the party.
Mister,
My lord, your lordship kindly
go to
see
the civil court.
page
No,
37.
no.
My lord, page
They have looked
37.
into it. You see, this court cannot exercise judicial review.
No,
on
no,
this.
my lord, your lordship kindly see, my lord, whether the order passed by the intune order, the learned ombudsman, my lord, has passed the order after hearing the parties, and my lord, whether this order passed by the learned ombudsman is.
Your contention has
arbit-
been, your contention has been mentioned out there.
No, my
Page
lord.
36.
My lord, observation and conclusion, your lordship will kindly see.
Understood.
my lord.
This court is not going to sit on this aspect.
No, no,
You-
my lord,
You have anything out there, you go before the civil court.
what I am submitting, my lord,
No,
this order passed by the learned ombudsman, my lord, is absolutely, my lord, without hearing us.
no,
And
there is no hearing and all these things to the effect.
No, my lord.
Representation of hearing for the complainant, Anup Kumar Nag was present, complainant disposed of. Why,
Well-
how do you say that you were not heard?
My lord, the respondent insurance, last paragraph, my lord, page 37.
Hmm.
The respondent insurance pointed out that the complainant has already claimed burglary of rupees 6 lakhs occurred immediately preceding so and so, so and so. Hence, there is discrepancy in the amount of stocks burglary.
I have read
Amount-
that, Mr. Counsel.
My lord,
No
My lord,
case.
my lord, then, my lord, your lordship kindly see.
Go to the civil court. No, go to the civil court. No, go to
My
the civil. No, you prove it. Sorry.
Learned ombudsman only relied upon the report of the surveyor, my lord. Now the Supreme Court said, my lord, the report of the surveyor is not sacrosanct, my lord. It cannot be.
It is a question of fact.
Correct, my lord.
You have to look into it. This court is not going to remand it back.
My lord, your lordship, unless, my lord, some materials are,
Learned counsel.
my lord, unless some materials are, my lord, considered, how can, my lord, the learned ombudsman say, my lord, I am entitled.
File sealing the order dated. Sealing the order dated.
25.
What is the date?
Yes, my lord, it is there.
What is the date? 25,
2020.
25/10/2024. Whereby the by the Insurance Ombudsman Gauhati, whereby the quantum of compensation which was awarded to the petitioner whereby only an amount of rupees 23,125 was held to be sufficient, was held to be reasonable as the quantum of compensation payable to the petitioner.
Whereas my claim was below 9 lakhs.
This court have duly perused the materials on record, and from the perusal of the materials on record, it is seen that on 18/3/2024, it is seen that it is the claim of the petitioner that the petitioner had taken up a policy, namely Bharat Tuksma Udhayam Suraksha policy from the Oriental Insurance Company Limited, covering the stocks of all kinds of clothes, saris, similar other natures of goods kept in the petitioner's shop. The sum insured was rupees 20 lakhs for a period from 2011-2022 to 23-11-2023. On 18/4/2023, on account of a storm, the roof of the petitioner's shop was badly damaged, resulting in the rainwater seeping into the stock of the petitioners, which was kept in his shop. The petitioner estimated the loss of the petitioner to the tune of rupees 9,70,000 and lodged a complaint on 19/12/2023, claiming an amount of rupees 8,79,540. The insurance company after carrying out the assessment, found that the petitioner was only entitled to an amount of rupees 23,125. And accordingly paid the said compensation. You got that 23,125? The petitioner received the said compensation under protest and thereupon filed an application before the insurance ombudsman. The insurance ombudsman, by the impugn order, based upon the survey report by the appointed licensed surveyor, upheld the decision of the insurance company to award an amount of rupees 23,125 to the petitioner. The petitioner, being aggrieved, has approached this court by filing the present writ petition. Mr. B.K. Sen, the learned counsel appearing on behalf of the petitioner, submitted that the insurance ombudsman have passed the impugn order in a perfunctory manner without taking into consideration the complaint which was submitted as well as the documents which were submitted in support thereof. The learned counsel further submitted that the insurance company, insurance ombudsman could not have merely relied upon the survey report and passed the award. This court have heard the learned counsel appearing on behalf of the petitioner and have perused the materials on record. The question as to whether the petitioner is entitled to a further amount from the amount which have been granted by the amount of compensation paid by the insurance company is a question of fact which needs to be proved before a forum wherein the evidence can be led. The petitioner has adequate and efficacious remedy before the consumer forum, as well as also, I think it is the best is consumer.
Consumer as well as civil suit.
Civil suit means, okay, or before the within court of civil jurisdiction, wherein evidence can be led as regards the quantum to which the petitioner is actually entitled to the loss suffered by the petitioner. Accordingly, this court is not inclined to entertain the instant writ petition. This court also takes note of that the petitioner have been bona fidely pursuing the instant proceedings, and accordingly, the period from 28 to 2025 till date be excluded while computing the period of limitation.
So they have to pay for passing over.
What?
The time being allowed.
Yes, Mr. Chaudhary, what are you getting, Mr. Chaudhary?
I am the tenant, my lord.
Huh?
Now unable to get in, my lord, injunction from the civil court, my lord.
Hmm.
Now all this procedure has been adopted, my lord. So in both side, on my southern side and eastern side, my lord, initially a kiosk was set up, which was removed by the corporation. Then
Who
we
has
put
filed
it
the
in,
writ petition?
my lord.
Who has filed the writ petition?
And then,
You,
I am the, yes, sir.
Now we have filed the writ petition.
Baljit Singh.
Baljit.
Okay, now what has happened?
Now, my lord, what had happened is, my lord, on the southern side, they set up an iron kiosk
Who?
by the landlord.
Okay.
My lord, then, my lord, it was removed by corporation. There's a lot of things going on for quite some time. Then on the eastern side, there's a corridor. There also, my lord, they have put up obstruction. Now, my lord, once the kiosk, iron kiosk was removed, they have put in and now a bamboo structure. Now, I have annexed the photographs. my
But
lord.
why a writ petition?
So, my lord, writ petition is, my lord, because, my lord, my right of way has been affected.
So what? Why a writ petition? Go to the civil court.
No, my lord, the civil court, civil suit is pending.
Then there you file application, ask for an injunction. Why this court?
No, my lord, there is nothing that this honorable court cannot take up this
Absolutely,
matter.
this court should not. Why? Civil courts are there. Why
No,
should
my
this
lord,
court?
with all respect, my lord, if my right under 19(1) is violated in a manner which is not countenanced by law, I need not go to
Who-
civil court for each
Who
and
has
every
violated?
dispute.
Who has violated?
The tenant has filed the writ petition.
Who has violated?
The, my lord.
Landlord.
My lord,
Landlord has violated.
no, GMC also.
No,
my
who
lord,
has put the bamboo structure?
No, why GMC has permitted? Why should I go to civil court and wait for
Yes.
10 years to get an
We
order?
can't allow this. Sorry. You can very well, it would not take much for filing an injunction application and getting it out there.
No, my lord, this matter is pending for quite some times now.
So
Now,
what?
this is the first time, my lord, we are confronted with this question.
I am shocked that why the notice at all was issued in this
No, my
matter.
lord, it has been issued. A coordinate bench of this honorable court has issued notice
Okay,
and has also passed order. And
Let
we have
us
also
see.
filed violation petition, my lord.
There cannot be a book. How,
No, no, there-
how
no, no,
there
I'll
can be an
respectfully
injunction
submit,
be
my
passed?
lord. It's not a matter where 226 court cannot hear. Even, my lord,
Let
there are
us see,
judgments
let
of the
us see when a purely civil matter
it's
is
not a
there,
civil
why this,
question,
how,
Lord.
how can a 226 court can exercise the
But
jurisdiction?
we also wanted the GMC to play its role.
Why should the GMC play a role? First of all, when it is an inter dispute between you and somebody, why you are bringing drawing the GMC?
No, my lord, I'll have to draw the GMC because without GMC's permission, a kiosk cannot be set up in front of my shop room.
Now the kiosk is not there.
But now a bamboo structure has been
So
brought in.
bamboo structure is a temporary structure. It can be very well set up.
No, but kindly have a look at the photographs, my lord.
Yes.
Let us not go to all these technicalities and see the what is reality is going on.
No, that, why will
please,
this court
please have my
exercise
writ
this
petition,
type
my
of
lord.
thing?
Please have my writ petition, my lord.
Yeah.
Please come to page 70.
Yeah.
On 15/10/24, this was the position. This is the southern side, my lord.
Mhm.
There is a road abutting at the Laktuke road.
Mm.
Then kindly see, my lord, on 2010, what happens.
What is
Then
this?
please come to, my lord, page 72. On 21/10, this is the situation.
Mm.
My lord, the wall is on the eastern side,
Mm.
and my lord, the kiosk is on the southern side. Then, my lord, see the position on 22/10. Unable to get an injunction, see the position on 23/10. See the position on 28/10. See the position on 28/10, my lord. I am a tenant. This is my lord, fate. 8/11, then 8/11, 8/11. This is how, my lord, things are being done. And, my lord, against the refusal of the injunction, there was an order by the honorable court.
Where is that order?
Please.
Did you file a suit?
They have filed a suit, my lord.
Why
They have
haven't
filed
you?
a suit for eviction.
Why haven't you filed a suit? That not to disturb, because the injunction can be obtained by either of the parties, the defendant also can obtain.
Yes.
Then why are you here? You should have filed an injunction application to
My
that effect.
submission is merely because there is an alternative remedy.
This is not an
Is it a
alternative
rule of
remedy.
law
It is a
that
question.
in each and every case, a writ petition is not entertainable, my lord.
No. This petition cannot be entertained.
Now, please come to page 54. My lord, there was at their instance, this order was obtained, my lord, passed by this honorable court. Now, my lord, humble submission is, how come municipality has permitted this?
You ask for injunction. What injunction? Where? Had directed, no, because the respondent have not obtained any deed of making any construction. He submitted no permanent is being made, and what is contemplated by the respondent is only a new tiles as regards painting. Both the
But we have not been able to
cannot
open
make
the
any
shutter.
major
Very
construction
specific
changing the
construction.
nature of the structure. This is an injunction being passed, that there shall not be a major construction. Where are you going to get the word permanent in that order? Major construction will be much bigger. But whatever may be, this court cannot entertain this type of information. Go and file civil suit. And what are the, now the kiosk is there?
Kiosk is not there, a bamboo structure is there.
Where is the bamboo structure?
Same position, my lord. And they say because of an order of this honorable court, they have done it. The photographs are there, my lord.
Which is the bamboo structure?
Yes. On last occasion, we have furnished the photographs.
No, that means as of now, there is no kiosk.
No, bamboo structure is there.
And have you mentioned about the bamboo structure?
Yes, yes, yes. In contempt petition, it is there. And court has passed orders, my lord. If your lordship would kindly take the contempt petition,
Hmm.
where we have annexed that order in this file only, my lord, 18/12/24. Page number 17. Bamboo structure is in the contempt petition, it is their photographs. Please come to order dated.
No. These type of things cannot be looked into.
Please
We
come to
dismiss.
my lord, order dated 18/12.
No, Mr. Chaudhary, I'm dismissing it. You go before the civil court. You get an injunction
And
today.
my lord, my lordship will record my submission
I'll record it.
that it is not that there is any bar for a civil suit, my lord. Number one. And number two, my right, if my right to under 19(1)(g) is violated by the authority, by the landlord in connivance with the corporation authority, I have every right to invoke this jurisdiction of this honorable.
Where is your allegation that there is a connivance with the GMC authorities? As of now, the kiosk is not there.
But
We are-
bamboo structure is there.
Okay, so where is that allegation as regards?
Yes. No, before that, lordship will kindly come to page 20 of the writ petition. Now, what is their perspective, which I would like to place?
Hmm.
Please come to page 20, clause 8,
Hmm.
paragraph 8. That the space between the footpath and the shop premises will remain under the exclusive ownership of the first party, and second party cannot use this space in any way or manner as he likes or causes inconvenience to the other tenants of the building. My lord, based on this, they would like to contend that that portion is a place where they can do anything, the landlord. That is their stand, my lord. Now, please come to my averments, my lord. Para 15. That the petitioner submit that inaction of the GMC authority is unreasonable, illegal, and refusal to exercise lawful power.
Have you approached the
Vested-
GMC for removal of that?
Yes.
Where is that? But anyways, that has been removed.
No, that has been removed. Now a bamboo structure has been brought in.
So have you approached the GMC on that? Where is that?
If your lordship would kindly take the contempt petition, my lord. Page 33. Page 31. We would like to express our.
This is as regards violation of the courts.
Hello?
This is as regards violation of the courts.
Yes.
As regards erection of the bamboo structures
Yes,
by
yes,
there,
yes.
that is not the question out here
Yes,
which
it
has
is
been
there,
brought
my lord.
today. No. By erecting the bamboo structure, they are violating the court's order is what it is your stand here.
No, at end of the day, my lord, we have brought to
Mr.
the
Chaudhary,
notice of the.
I'll
GMC.
record your submission and dismiss
Yes,
your
yes.
repetition. Heard Mr. K. N. Chaudhary, the learned senior counsel assisted by so-and-so, appearing on behalf of the petitioner. Who is appearing for GMC? Mr. So-and-so appears on behalf of the respondent numbers 1 and 2. Who is appearing for 3 and 4? Mr. T. Mojumdar, the learned senior counsel, assisted by so-and-so, appears on behalf of the respondent number 3 and 4. The present petition has been filed by the petitioner. petitioners seeking a direction upon the respondent number 1 and 2 to demolish and or remove the boarded iron block measuring 7 feet by 10 feet by 2 feet installed in the space in front of the petitioner's shop, and also the brick wall on the right side blocking the ingress and egress of the petitioner's shop at the ground floor at SS Road, Laktokia, Gauhati 781001. And further, also seeking a direction upon the respondents to clear the said space from any other encroachment or construction after following the due procedure of law. The brief facts which led to the filing of the instant writ petition, as would be available from the materials on record, are that the father of the petitioner, namely one Mohanjit Singh, was a tenant of a premises is a tenant of a room situated over a plot of land at measuring situated over a plot of land covered by dark number 421 new 2213 old of KP Patra number 130 new oblique 1230 oblique 771 old. It is the allegation of the petitioner that the respondent numbers 3 and 4, who are the landlords, have filed a suit against the petitioners for eviction on the ground of violation to the provisions of Section 5 of the Assam Urban Area Rent Control Act 1972. Now, on the grounds provided under Section 5 of the Assam Urban Area Rent Control Act 1972. In the said suit was registered and numbered as title suit number 291/2024. Along with the said suit, an injunction application was filed, which was registered and injunction application was filed, thereby restraining, seeking an temporary injunction for carrying out any remodeling or reconstruction of work in the said premises by the petitioners. The said injunction application was rejected no ex parte injunction was granted. Resultantly, the respondent number 3 and 4 preferred an appeal, being Miss Appeal number 16/2024. In the said appeal also, there was no injunction granted. Under such circumstances, the respondent number 3 and 4 filed a proceedings before this court under Article 227 of the Constitution, which was registered and numbered as CRP IO number 402/2024. The said revision application was disposed of, thereby directing the learned trial court to consider and decide the injunction application, and further observing that no major construction should be undertaken by the petitioner that would change the nature of the suit premises. It is the specific allegation of the petitioner that in spite of that having failed to obtain an injunction, and in order to harass the petitioner, the respondents, number 3 and 4, have set up a kiosk, have installed a large iron block with boarded sides in front of the shutter of the petitioner's shop. Photographs in that regard have been enclosed as Annexes 7 series to the instant writ petition. First, the petitioners have written a letter to the respondent number 2, that is the Commissioner GMC, for dismantling and demolishing the said unauthorized structure, which have been installed on the space between the shop and the pavement. First, the respondent number 2 and 3, respondent numbers 1 and 2, having not taken any action on the basis of the said representation, the petitioners have approached this court by filing the present writ petition seeking the reliefs as aforementioned. First, the records reveal that this court, by an order dated 17/12/2024, issued notice and further directed the GMC authorities to remove the erection of the structure which is stated to have been placed in front of the shop of the petitioner by following the procedure of law. It was further direction that the direction for removal be carried out within 24 hours from the date of the said order, and compliance to that effect be filed by the GMC authorities, giving all particulars as may be necessary to take necessary steps towards complying with the directions issued by the court. In pursuance thereto,
Next day, there was a modification that order made.
huh?
18, this order was modified.
Where?
Page 11 of the contempt petition.
Page?
Page 11 of the contempt petition that order is released. 17 December.
The records further revealed that pursuant thereto, pursuant thereto, the very next day, that is on 18/12/2024, the learned coordinate bench of this court modified the order dated 17/12/2024 whereby the GMC was directed, authorities were directed to issue notice to one Mahmoud Alam, if not already issued, and thereafter upon due verification shall decide on the aspect of grant of trade license to such person to run the shop at the same premises where the kiosk is permitted to be erected, and also to examine whether there is any violation of the building bylaws oblique rules under the GMC and GMDA authorities by the said Mohammed Alam and the respondent number 3 and 4 while executing the said tenanted lease premise agreement between them. It was further directed that if such violation was noticed, appropriate action shall be taken by the GMC authorities under the provisions of law. The order dated, it was further directed by the order dated 18/12/2022, 24, that the respondent number 3 and 4, that is the respondent number 3 and 4, shall also ensure that the removal of the obstruction on the eastern side and ensuring entry and exit through the southern side within 3 days from today without affecting the kiosk of Mohammed Alam. The records reveal that the respondent numbers 3 and 4 had filed an affidavit in opposition, wherein they relied upon the agreement, the tenancy agreement entered into by and between the petitioner's father and the respondent number 3 and 4, and more particularly to clause 8. It was further mentioned that the dispute between the petitioners as well as the respondent number 3 and 4 are pending adjudication before the learned civil courts. It is of relevance to take note of that on 18/3/2025, the structure for which the instant writ petition was filed was dismantled by the GMC authorities, isn't it? The said aspect would be apparent from the affidavit in opposition filed by one Mahmoud Al Alam, who has been arrayed as the respondent number 5 in the instant proceedings. Anyways, that is also should be brought in and that is also to be discussed.
Parasitic there, it's 18th it was removed by GMC, 19th the tenant has put it damaged.
Yes.
19th. Yes.
So it is the opinion, first of all. In view of the removal of the kiosk by the Gauhati Municipal Corporation by the GMC authorities on 18/3/2025. The very petition, the very grievance of the petitioners, who are the respondent number 1 and 2, no longer survived. First, be it as it may, Mr. K. N. Chaudhary, the learned senior counsel, has submitted that this court should pass appropriate directions against the respondent number 3 and 4, that they should not, in connivance with the GMC authorities or other authorities, disturb their possession and enjoyment of the tenanted premises. The learned senior counsel submitted that the rights under 19(1)(g) of the petitioner could not have been violated by the respondent number 3 and 4.
Not respondent number 3 and 2, GMC authority. My case is, it is GMC's duty to
But that has
ensure-
been removed.
But bamboo thing has been brought in.
Bamboo, you have not approached the bamboo. You have not approached as regards violation, you have approached.
There is a subsequent restraint order of this honorable court also. Let me make my, because since your lordship is recording the order, my lord, therefore I must point out the correct facts. My case is how GMC permitted this thing to happen. Naturally, the beneficiary is respondent number 3 and 4. If GMC would have exercised this jurisdiction, then this situation would not have arisen, my lord. That is my case.
No, but it has been removed.
It has been with the kiosks, but the bamboo thing is still continuing.
Bamboo is not the subject matter of the writ petition.
It is.
Where? By way, are you saying by way of an IA you are submitting that it is a part of the writ petition?
Kindly come to the prayer in the writ petition.
That is what I am submitting,
Yes.
mentioning out there.
Yes.
That this court should continue to look into this, that they should not in connivance with the GMC should do it.
There is a civil suit pending at the instance of the tenant.
No,
landlord.
Mr. Chaudhary, kindly listen. I have passed an order, I have recorded it, that the respondent number 3 and 4 in connivance with the GMC should not violate the rights under Article 19(1)(g) of the petitioner. That is your submission.
It is my submission. Lordship would put it other way around. It is GMC who should not have permitted. That is our case. Para 15 I have already read. Our case is, my lord, if GMC would not have permitted, this could not have happened. That is our case, my lord. Since your lordship is-
Let's see your relief prayer. Read the prayer in your writ petition. Where is it?
before that, please come to
No,
para 50.
first come to the prayer. We are not going to see those submissions. See the prayer one.
Please 1-5.
1-5.
Read in the nature of mandamus directing respondent 1 and 2 to demolish or remove the boarded iron block measuring so and so installed in space in front of the petitioner's shop and also brick wall on the right side blocking the ingress. So this is my main prayer, Miller.
Go ahead.
Yes. So and so, so and so, so and so, so and so. And clear the space from any other encroachment construction after following the due procedure of law.
Now, once that has been removed on 18(3), where is your subsequent cause of action? I think the bamboo structure here in the writ petition.
It is a subterfuge which the tenant had resorted to, and 226 code will not even take note of that. Kindly see, my lord, how they are trying to overreach the authority of the honorable
No,
court.
you have to go and file a civil suit.
No, my lord, not necessarily. That's my argument.
No, that is what
Yes,
I am
yes,
saying.
yes.
The 18 and 19(1)(g) in collusion with the GMC authorities. It is the further submission of the learned senior counsel that though the 7 feet by 10 feet, though the boarded iron block measuring 7 feet by 10 feet by 2 feet installed in in the space in front of the petitioner's shop was removed. But the respondent number 3 and 4 immediately thereupon, in connivance with the GMC authorities, have erected a bamboo structure. The learned senior counsel further submitted that this is a specific case where the proceedings, the orders which have been passed by this court have been made redundant by the respondent authorities number 3 and 4, respondent number 3 and 4 in collusion with respondent number 3, 4 and 5 in collusion with the GMC authorities. First, this court have duly perused the materials on record and have heard the learned counsel appearing on behalf of the petitioners. First, the dispute in the instant case is a dispute by which the petitioner is seeking, is purely a dispute between the petitioners as well as the respondent number 3 and 4. First, the public law remedy has been sought to be invoked by the petitioners. Which aspect the petitioner could have very well agitated before the civil courts. More particularly, when the question arises as regards clause 8 of the deed of agreement between the petitioner's father, between the petitioners and the respondent numbers 3 and 4. First,
Southern side. This side, the southern side, where they will have and not have any agreements.
considering the above, as at present, as in pursuance to orders passed by this court, the GMC authorities have already removed the iron block, boarded iron block on 18/3/2025, comma. The further continuation of this proceedings, the present proceedings, which is purely a civil proceedings between the petitioners as well as the respondent number 3 and 4, could be an abuse of the process of the court, for which the instant with petition stands dismissed. Interim orders, if any, stand vacated.
Just one observation, Dr. Savar. So far as my instruction is concerned, Dr. Berry has been clearly stated that the present structure is in violation of the regulatory, the framework.
That
governing
is-
land use and building.
Needless to mention, before parting with the record, this court, however, observes that if there is any violation to the to the building bylaws, to the GMC Act or the bylaws, comma, the GMC authorities would be at liberty to take action against the structures which have been constructed over the land constructed in accordance with law.
Within a time frame.
That's in accordance with law. Because I can't give time frame because he got an injunction. Stay, that repetition.
The same fate should follow him also, my lord.
That matter is not here now today.
Decided.
Decided, but finally status order is there, maintained.
Status quo saying that till the GMC decides on their matter, the status quo will.
So the same thing will happen.
So that time frame will be.
Why should I give a time frame?
My lord, my lord, there's
I
a
closed
contempt petition.
Contempt, yes.
Contempt.
Contempt is against whom?
Contempt is again respondent number 3 and 4.
Tell. How are you going to prove it?
My lord, we're page 17, my lord, this portion of the order. Respondents number 3 and para 17, page 17. Respondents number 3 and 4 will ensure removal of the obstruction on the eastern side and ensuring entry and exit through the southern side within 3 days from today without affecting the kiosk of Mohammedan. This observation was made in view of para 14, my lord. Now, the fact that the kiosk has been removed, but they're not supposed to have any obstruction on the southern side and eastern
In
side.
the earlier order, didn't I vacate the interim order?
My lord,
Didn't I vacate the interim
my
order?
lord. Question is, there is a rightly or wrongly, there was an order of this honorable court. That has not been followed. It is in that light, my lord, the contempt proceeding has to be, my lord.
Now is okay. How will you prove it?
My lord,
How will you prove this? That they are having an obstruction there?
there's the photographs.
No, how do you prove these photographs?
No, my lord, they have not denied also. And you see, from
Southern side.
page 19 onwards.
Will
19,
Will
20.
ensure the removal of the obstruction on the eastern side
Hmm.
and ensuring entry and exit through the southern side within 3 days from today without affecting the kiosk of Mohammed Alam. Now Mohammed Alam's kiosk is gone.
Now it's.
So now,
So the obstruction will happen.
now there is still an obstruction.
So on that day, this order was there, my lord, rightly or wrongly. Today, lordship has modified or vacated that order. That is otherwise.
Okay, now prove this, that there is an obstruction. How do you prove it? Forget about them denying. This court is it's a quasi-criminal proceedings. You have to prove it. When are you going to adduce evidence before this court? Evidence.
I'll need evidence.
Okay. When? When are you filing your evidence on affidavit?
We'll file it by Friday. Friday. Oh, plan.
File it.
Lord. My lord,
Evidence
before
on, you will
13,
cross-examine
before
him.
13 will.
And one aspect I need to point out, the tenant who has put up the bamboo structure, they have taken a stand that they have done it. So they are not a party in this case.
No, it's okay. No, let them prove it.
Right.
We'll see how it they prove it. As of now, what is there? Is it still continuing?
Same position.
But I have vacated the order.
My
This
lord.
order no longer remains.
No, it's not a question of vacating or upholding the order. It's a question of lawlessness which is prevailing. my lord. That's the
Understood.
whole difficulty.
Understood. But as of now, that order is no
Lord,
longer.
there is the order of the court and there my lord, with all impunity, they are flouting it. That's the only
Understood. So
position.
therefore, the question is, you should have gone before a civil court. This is not a forum.
Why should
The problem
they
is
fail
that,
to
no,
obtain
how can
injunction?
this order be, this is a writ being issued against the private respondent. This is a writ, normally you don't issue a writ in this anger unless he is drawing some
My lord,
authority
My lord,
from
we
the,
also
yeah.
know that position that read normally does not lie against a private person. But there is no rule of law that in all situations read does not lie against a private
No,
person.
understood. But if he is drawing some authority, just for example, a person is that got a contract from somebody, then obviously the private respondent can be issued. But here he is
There are-
exercising his independent
In an
right.
appropriate fact situation, there could be an exception. It is not an absolute proposition that read cannot be issued against a private party in all situations. There are exceptions.
I
And
think
I'm
you
not-
file an appeal against this also. I'm
We
dismissing
have to
this.
file an appeal. There is
Yes.
no dispute.
No,
We'll file.
again this.
Because end of the day, my lord, the
This is an
proposition-
application alleging willful and deliberate violation to the order dated 18/12/2024, passed by the learned coordinate bench in WPC number 6119/2024. The allegations made in the instant application is that the directions which were passed in paragraph number 17 of the order dated 18/12/2024 in WPC number so and so have not been complied by the respondent number, by the respondents in the instant proceedings. Pusto. This court had already, by the separate judgment and order dated Adidito, dismissed the writ petition being WPC number 6119/2024. And have also vacated the interim orders passed therein. The said was done on the ground that the dispute between the petitioners as well as that the dispute between the petitioners herein as well as the respondents who were the respondent number 3 and 4 in the writ petition was purely a landlord-tenant dispute whereby the public law remedy under Article 2 to 6 have been initiated. In view of the dismissal of the writ petition, as well as the interim orders having been vacated, the order dated the direction so passed in the order dated 18/12/2024 in WPC number 6119/2024, more particularly at paragraph number 17, no longer continues to hold the field. It is also very relevant to take note of that a contempt jurisdiction is between the contemner and this court. And it is the opinion of this court that after vacating the order, after vacating the interim order dated 18/12/2024, there is no necessity for this court to further pursue the instant proceedings. Accordingly, the instant contempt proceedings stands dropped.
Lord, in this case, a proceeding under the Lord sexual harassment in workplace case was initiated. Now, my lord, when the earlier proceeding was going on, the petitioner was in custody. Therefore, my lord, the evidence and all were taken in his absence. Therefore, my lord, this honorable court interfered with that said order. That order lordships will get at page number 43, and the relevant portion is at page 52 and 53.
Mr. Chaudhary,
Yes,
can you see your,
my lord.
can you show me how is your page 52?
Yes.
See, how can one read it? See this? See this?
You know, I didn't know about the court position. I know. That's why, my lord, yesterday I took out a page for myself.
Nobody can read it.
My lord, this is the
No, it's okay. Now let's see.
yes. Anyway, my lord, what had happened? Please come to, my lord, that page. It reads like this. Therefore, the court is of the considered opinion, that para 24. If petitioner is not granted one opportunity to participate in the ICC inquiry, proceeding by filing this written statement of defense and to cross-examine the witnesses, the petitioner is likely to suffer irreparable prejudice which cannot be undone in course of departmental proceeding for the reason that in the ICC proceeding, no written statement of defense of the petitioner would be on record. Moreover, evidence of 14 witnesses examined by ICC would remain uncontroverted without any cross-examination whatsoever.
Mr. Chaudhary, there is a recent judgment of this is J.K. Maheshwari and this is Bishnoi.
On this Act 2013.
After taking into account, there is another notification which is being issued by the central government. Here, Numuligar also has to follow that.
Yes, same principle.
And you have the judgment
No,
because there
I-
it lays down how it is.
Here position is slightly different.
Yes.
Now, my lord, there was a criminal case. In the criminal case, I got a discharge. Now, in view of that, my lord, the complainant now doesn't wish to proceed with the matter. That is what we have brought on record.
And what does the ICC say?
That is what, my lord. Therefore, if your lordship will kindly have a look at this, the affidavit which we have filed.
Prayer for closing. This is by the presiding officer.
Yes, yes.
This is at page 69. This is page 69. This
Yes.
is, I think, the communication.
Huh?
What is the petitioner's name? Okay, you are the person.
Yes,
You have written this.
yes,
Now, the complainant does not want to take it up.
yes.
Where is that? Where? In this petition? And no objection affidavit by so and so. After completion of the investigation, submit the charge sheet against the petitioner while the
Page 84 is the application, my lord. And page 88, 87 is the order passed in criminal process, criminal case, my lord.
Come to page 92.
90,
92. Which is the part of the affidavit filed by the complainant.
92, my lord.
Yeah.
The deponent begs to submit that after completion of the investigation of Gulawat, the investigation submitted charge sheet against the petitioner. While the trial case was going on before the Honorable Sessions Court, the petitioner had initiated a criminal petition before the High Court, which was registered as so praying for quashing. The opponent begs to state that she wants to settle in her life and engage herself in conjugal relationship, and as such, the opponent submitted the issue pertaining to registration of the. She did not want to proceed legally against the petitioner. Further, the opponent also filed no objection affidavit in the aforesaid. In fact, my lord, the criminal case order of this honorable court is at page 87, my lord, and the operative portion is at 89. Paragraph 7 towards the bottom of the page. This court is of the opinion that this is a fit case for exercising power under section 528 of BNSS. Accordingly, criminal proceedings of sessions case pending in the court of additional session judge is quashed and set aside. Then, my lord, based on this, at page 84, she writes to the ICC, my lord, that she would not like to pursue it.
No, in fact, she has, interestingly,
affidavit.
she has filed an affidavit before this court. Now, can this be done in that manner? Closed, can a proceedings be closed in this
It is
manner?
something like this, my lord, if she does not depose, now the proceeding has
that's
to start
another thing.
afresh. Then what will be there? What will be proved?
You have to, that judgment is relevant, how the court, how the, has
I
to
think-
proceed.
No, look, there was initially a judgment of the Supreme Court
Hmm.
that ICC report should be treated as an inquiry report,
Inquiry.
and proceedings should start from that stage.
There are
Well,
there are two things.
Huh.
One is ICC will first investigate and thereupon submit it to that to the what you call that, the departmental inquiry body,
Yeah.
to the employer. Then employer on the basis thereof shall look into it, and if necessary they will go for if they want, they can go for a departmental discipline proceedings.
Initially, the view taken was that this itself should be treated as an inquiry report, and from that stage, the proceedings should proceed.
Uh-huh.
But subsequently, well, the view of the Supreme Court is no.
No,
Based on that, charge should be framed, departmental proceedings should go ahead.
no, that is not there. First, this ICC will look into it. After the ICC looks into it, the matter goes, they will submit a report. If it is made against the person concerned, then the departmental proceedings will initiate. Now, again, the fact finding, again, the ICC will look. This is a preliminary inquiry. Then the fact finding happens. Then again, the ICC will look into the on a second stage, whereby evidence and all these things will be properly looked into. And thereupon, They will submit a report and the decision as to whether punishment is to be given by the departmental procedure.
Department.
This is
I
as
think to
per
that
a particular.
extent- to that extent, there is a amendment to the CCA rules also.
That is why they have amended.
14, I think they have introduced that.
I have also passed a judgment on this because I know about this thing because of the fact that there was some officer out there pertaining to, we call this IIT. Yes, IIT was a case where there was some stay being granted and all these things had happened. And there I took note of that judgment of Justice J.K. Maheshwari and Justice Bishnoi. That this is a very recent judgment sometime in the year 2026, January or something.
I'll have to.
Yes.
To that.
So there, whether it can be done or not, what is the first form of an inquiry? If it can be that there is no useful purpose, we can quash it. That is the only thing we need to look into.
And I'll look into it.
Yes. Then I have delivered the judgment, in my judgment also duly dealt with that aspect.
I'll look into both the aspects.
Yes. And what is this IA business?
What's it, one I,
Mumuliga, why are you filing the IA?
what's it, we have filed an application for vacation of the stay order.
What's the?
What's it, there is a stay order dated 88/2025.
Where?
ICC proceedings being
So
suspended.
as an interim matter, the further procedure shall remain suspended.
Gotcha. In fact, Lordship, prayer number 2 and 3 are infectious because since respondent number 4, Miss Ranjana Chakraborty was there and she has completed her 3 years term and thereafter,
Prayer number?
Lordship,
Prayer?
prayer
Two.
2 and 3, requisal of the respondent number, prayer of the repetition, Lordship.
No, which has become infructuous?
Respondent, Lordship, prayer number 2 and 3, Lordship.
Of?
Of the repetition.
Repetition.
We have prayer ABC.
Lordship, Lordship.
Read in the mail should not be here to recuse the
ABC.
respondent number 4 as the presiding officer. So this has become, he's not there. Read in the nature of so and so should not be to set aside the decision of the remand for recusal of ER. So that is gone. 3 and 4. So only thing is for quashing the internal communal proceedings.
Lordship.
Now the question is by way of a compromise or anything to that effect, if he leaves out, would it be permissible? Would it be an abuse of the process to continue?
Yes.
Because now in view of Justice Surana's judgment, it has to start fresh
Stress.
from zero. So therefore, these are two stages. Mr. Chaudhary, you have a look at the judgment out to the effect.
Let it come after the vacation. then I'll
After
look
the
into it.
vacation, we'll look into that aspect.
Lordship, Lordship, I have to submit one thing. The Lordship, they have filed a writ appeal also by challenging the writ petition order and review order. Also.
Who has filed?
Petitioner has filed. Petitioner has filed. There is filing number 9686/2025. It is
And that has not been moved there. There is delay. And I'll look into both the judgment, let the matter be called after the vacation.
Okay. So we'll consider on that day
Yes,
after
yes.
vacation because there is an interim order. Yes, Dr. Sohail Malik. Here if you see, here specific, whether ICC considered in one department or this is important, there they take into account this particular judgment.
The question could be whether it is compoundable or not, something like that.
This is the only issue. Otherwise, it is not there because
Whether it is
can it be
compoundable-
later on? Because if we hold it, just for example, without looking into that law, if we hold it, yes, the age is not doing to, so there would never be anything. It may have a result of taking winning over in all matters. This has also far-reaching
So
consequence.
that's- they have to look at the legislative policy.
Content.
Legislative
And
intent.
and apart from that, the question is, can the ICC close it? Now, we can very well ask the ICC to look into this in view of her affidavit and place
It's a
it.
different matter that if she does not come and
Huh.
lead evidence, nothing is going to
Nothing is going to happen. So that might be a thing which we may have to give. Because if we have it as a universal proposition that this will happen immediately, then in all cases there will be, you never know, pressure will be avoided. And therefore, list this matter, taking into account that there is an interim order which is presently in force, and there is an interlocutory application filed for vacating of the said order, it is the opinion of this court that the matter requires to an urgent disposal. Accordingly, list this matter on 21st of July 2026, on which date an attempt shall be made to dispose of the.
Deeply opposed.
All right, deeply.
You take that, huh, Sohel, Dr. Sohel Malik.
Not interim, sorry.
E. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. R.K. Talukder appears on behalf of the respondent numbers 1 to 4. 1 to 4. What about the others?
Sitting here.
I appears on behalf of the respondent number 3. Mr. J. Hendig appears for respondent number 5, 6, and 7. This is an application for seeking recall of the order dated 8/6/2026, whereby the petition was dismissed for non-prosecution. This court have duly perused the grounds on which the instant application has been filed, and it is the opinion of this court that this is a fit case for recalling the order dated 8/6/2026, which was dismissed for default, by which the accompanying writ petition was dismissed for default. Accordingly, the accompanying writ petition is restored to the file. Which I stands to. Okay, now what is your case?
Lordship. The Lordship, now in the case, Lordship, come to the order dated 13/5/2026. Whatever the petitioners, the entire Lordship, this order, if permits, Lordship, I read this order, everything will come up. I'd be some learning counsel, then Tunglung landed counsel for the representing R.K. Talukder stating so. NSCDs of respondent 2 and 4, and Mr. B.H. Talukder, senior learning counsel, assistant P.K. Medi, and so. An area of land weighing 15 lakhs covered by tag number 159.
You are asking for some compensation.
Compensation, Lordship,
For what?
for damaging my entire tea factory, everything by.
Go to the civil court.
No, Lordship.
Why
Here
should
what
we
happened,
look
Lordship,
into
kindly see, Lordship, my
Yeah, if something
representation.
has happened, if it was a tea factory on account of acquisition,
Yes, Lordship.
then it is a part of the JIRAC. Then you should have one that you have not got the compensation for the JIRAC. Why are you here?
No, Lordship. Here kindly.
No,
The
It's
order
not
part,
that.
kindly
You-
read the-
This
what
court
happened,
cannot.
Lordship, by
Now
represent-
tell me, if I pass an order to make the payment also, how tomorrow it will be settled that they have made the payment for these things? This is a thing which is, these aspects are already given as regards, this is the case under National Highway Act.
National Highway.
So it will be under, you have to go under 3G5.
Already payment, some portion of payment we received, Lordship.
So then you have to go under 3G5 if you
Yes.
have anything out there. This is not the question where you have all these thing losses. You have now you already have the document out there. Go out there and file an application under 3G5 for your compensation. This court cannot look into this aspect.
No, Lordship, kindly, just the order in what happened, Lordship, the Kala authority, the ADC, recently before this court in paper stated that 5/12/2000, wherein it is entirely stated that he is not in a position to take decision and forward any estimate to acquiring authority, as he has not received any report either from the Tea Board or from Assam Agriculture University. He asked us in 2015 to assess the same from the government valuer by his nature. Then in his affidavit, he admitted everything in paragraph 11, 13 and 14.
Whose affidavit?
Respondent number 6 affidavit. That's why the
Ma-
last
ma-
date the court passed the order.
Mr. Counsel, why are you not understanding?
Yes, Lordship, I
Once
got it,
he
got it.
passed the award,
Yes, I got it.
then once that he becomes functions officio, you have to go to the arbitrator if you want a higher compensation. Your JIRAC value have not been paid. So for that, you have to go under 3G5. This is not the process.
Yes, sir. Lords, upon taking into consideration all
No,
these things,
this, but that is the big problem. What happens out here is we tend to sometimes get moved away and go inside something things which this court cannot do so. Because if we do that, once we pass orders to that effect in this case, means we are changing the award. Now, if we pass the direction to payment of particularly, we are changing the award. The award is already made. It is a documented thing.
look, this last order, Lordship, it is clearly reflect that's why I'm only reading this part.
Which one?
That Lord's order, kindly see that one, 13/5/2026
Of
Last-
this court.
of this court, your number.
Yes.
That's why Lordship has come to paragraph 3, 4, and 5 of the order will reflect everything.
In view of that, Mr. Judge shall ensure the instructions are placed before respondent by respondent as regards the time period within which the process can be brought to a logical conclusion. An affidavit has been filed by wherein it is entirely stated he is not in a position to take a decision forward and estimate to the acquiring authority as he has not received any report from the Tea Board of Year. And the process of assessment for the plant and machinery installed in the factory has been initiated as far back as on March and continued. Such process is required to be brought to a conclusion as expeditiously as possible, and petitioner's right to property is connected with the matter of assessment and disbursement of the compensation entitled.
So long pending matter, ADC for the first time before this, so now said he did everything. Now he's saying
And this court cannot look into this, sorry.
whatever good for the petitioner, kindly Lords direct so that there is admission to that part. And
No,
government also in
we will
affidavit admit.
consider this. We will
Yes.
say that I give you the permission, liberty to file a RIA, and you go and file your application as regards the loss which you have suffered, and the arbitrator will duly take note of it. Because we are not going to look into this, and any report you are to prove that. It is your duty also to prove it.
That will be, but
You
regarding
prove
the
it through
delay
these,
part,
no,
everything-
you prove it through, because obviously his functions officio. He's right. The respondent number 6 is right in his affidavit. His functions officio, he cannot. Once, has the award been passed or not?
that part is not included.
So
Yeah.
once the award has been
Award-
passed, you
Yeah,
have
yes.
already got 47, around 50 lakhs.
Yes.
You have already got your
Yes.
50 lakhs. Now the question is whether you are entitled to further compensation or not. It is a question before the arbitrator. This court cannot look into that. Therefore,
So
heard
only
Mr. P.
regarding the
Sharma, the
limitation
learned
have to
counsel,
be covered, Lordship.
appearing on behalf of the petitioner, Mr. So-and-so. Mr. R. Talukdar, R.K. Talukdar appears for respondent number 4. Mr. So-and-so appears for respondent number 5, 6, and 7. The petitioner herein is aggrieved by the action on the part of the respondent or respondent authorities in not including the value of the loss sustained by the petitioner to the factory building as well as the attached machineries on account of the acquisition of the land in the award so passed by the competent authority for land acquisition under section 3G1 of the National Highways Act 1956. First. Section 3G5 of the National Highways Act 1956 makes it abundantly clear that if the petitioner, if any person is aggrieved, if the person aggrieved is dissatisfied with the quantum of compensation, the said the person aggrieved has to file an application seeking reference to arbitrator to decide the quantum of compensation, the inadequacy of the quantum of compensation. Because it is also well settled by the Supreme Court judgment, by the Supreme Court in the case of so-and-so versus so-and-so reported in 2022-15 SEC page 1. That while assessing the compensation, the party, the competent authority of land acquisition as well as the arbitrator has to take note of the provisions of the right to fair compensation economy 2013. More particularly, paragraph number 26 to 30 of the said Act of 2013, read with section 3G7 of the National Highways Act 1956. Thus, taking into account the above, as the petitioner's grievance lies in on the question of inadequacy of the compensation, whereby the petitioner has an adequate and efficacious remedy under section 3G5 of the National Highways Act 1956. It would not be proper on the part of this court to exercise the extraordinary jurisdiction in the facts of the instant case. Accordingly, the instant with petition stands disposed of with the following observations and directions. Number one, this court is not inclined to entertain the instant with petition. Number two, liberty granted to the petitioner to file an application under section 3G5 of the National Highways Act 1956. And if such application is filed, the authorities concerned, the authorities concerned as well as the arbitrator shall duly consider such application in the light of the judgment of the Supreme Court in the case of so and so. Super. Okay. Okay.
Take.
What is this?
Also, this matter came up before the Lozima Court on 18/6/2026 lordship because we could not provide alternate address of the respondents, your lordship. 14 and 15. A prayer was made before the court that will be permitted to trustee service. The Lozima Court not.
Who are you? What is your case?
Registered Thomas lordship, we have challenged.
What is your case against the private respondents?
Regarding meeting, your lord.
Huh?
Regarding meeting, lordship, the council,
Oh,
as per council meeting. So they are all members of the council.
then why are you filing here? Civil court?
Let us take the steps, your lord. Let us take the steps for now.
Let us dismiss the case so that you can take steps before the civil court. No, you have a problem as regards the meeting.
Good.
The meeting must have not been held as per.
But 2 days notice was not given.
So, what is the interim order passed?
There are no financial, nothing to do with financial implication will take place. Lordship, otherwise they can go ahead with their.
No, they are duly elected body, isn't it?
Yes.
How can we pass this interim order?
The final,
No, any final, anything done will be subject. You were also contestant. Then how can you say that they are, because of the notice not being granted out there, the entire thing will go? But how are you concerned with this no major decision?
regarding financial implication, Lordship,
So
otherwise
what?
they can go ahead with the other.
That means they are not able to carry out any work which has any financial work. Not possible. Possible, Mr. Bhuya?
No, no. Lordship is correct in saying that.
Obviously, you'd say I am correct, but that doesn't matter. My question is, how is it possible? Huh? Huh? Or you want to call your senior before I dismiss
Lordship,
it?
we're just praying for steps, sir.
I'm not extending the interim order. I can't interim order, I can't extend this type of interim. And why, you have filed your affidavit, no?
Yes, sir.
Oh, then forget about them. Let us see the affidavit. What is this? What is your stand?
We have stated in our stand that the election process and everything is in accordance with the
Okay.
pharmacy rules.
Affidavit filed by the Register 4.
Lordship.
Where is that?
Page number,
Paragraph?
paragraph 4, Lordship. Operative court would be in page number 44.
Initiated in accordance Pharmacy Act and Iman so and so. And that the election of the 6 members of the Iman was initially notified by the President come so and so on so and so. Wherein it was proposed that the election would be conducted through digital mode. However, the said notification was subsequently challenged by so and so. Read appeal number so and so and so and so, mainly on the ground that 8(2) of their elections were required to be conducted through ballot paper. Subsequently, in compliance with the Iman, the President so and so dated notifying the elections would be conducted. Accordingly, election of the Assam Assembly was conducted on February 1 and the result along with the names of 6 candidates were published in the so and so. The opponent executed the election result was challenged in the Gauhati High Court Iman and by the order directed the Iman to examine the matter in accordance with law. Compliance to the order, the government to examine after examining the report of the issue, the speaking order whether the election process was examined in detail. Further, during the relevant the register we have proceeded on leave and finally resign effective. So and so resulting in an administrative vacuum in order to ensure continuity in the day-to-day functioning of the environment. Appointed cannot be active of the register in charge of the environment. Considering the government also constituted a committee for negotiating the process of appointment of the individual to person to represent subsequently certain administrative reminders with the will proceed the government for the document to remove directly in order to maintain Yes, Mr. Gugoi. What is it?
We have passed an elaborate speaking order.
Ah,
Everything is here. And it is functioning now, madam. After a long period of 3 years, madam, it is functioning.
This type of matters should be finished. What is the violation?
But the register was not appointed as per the regulation.
Huh? The
Paragraph-
register in charge was appointed.
Lordship, paragraph 9 of our expedition.
What does it say? Like to state the
Respondent
respondent
number
number
4
4 is not
to be-
eligible for being appointed as in charge register of the Assam as she does not possess the Bachelor of Pharmacy degree or Diploma of Pharmacy from any institute approved under 12. At this stage, the communication begs to bring to the notice of this court the communication dated so and so issued by the authorities will remain to all the registered agreement issued by the communication dated was issued in terms of the system and that of the foreign No, he was only an interim register.
Interim.
The meeting called Lordship, it is void ab initio.
How?
As she could not have called for because she does not possess the necessary degree law. To be the in charge.
What meeting did he call?
The extraordinary meeting, Lordship, under the presidency of respondent number 5.
Where?
Which
Which meeting you are challenging? Let us see. The first meeting?
The first 4 to 20.
Huh? Which meeting you are challenging?
4 to 20.
Page?
Annexure 33.
Annexure?
32.
1 3. Page?
Page 33 only. Annexure.
Approval of the executive committee of the Assam Government. With the Iman, I have the honor to hear. With the copy of the newly formed executive member elected by the Iman. First meeting of the Iman. The meeting was convened in pursuance to the letter dated so and so, election to so and so, so and so. Member so and so comes, he is the in charge. You were a party here? Were you present?
But you'll see the minus in page 34.
34th.
Yes, next page.
That is what I'm saying. Members present in the meeting. Where did people?
These
There?
are the elected ones, my lord, and these are the elected ones, my lord, as well as the ex officio members.
Ah.
And the council, my lord, this was called for, and my lord, since at that time there was no register. The additional secretary was holding the post of in-charge register, and she had to call it, my lord.
She could not have called what, for the
Election of the result that the following members be hereby elected as executive members of the council. Surajit Tamuli, Matiu Rahman. Results were unanimously elected as PC and the so and so. So and so and so and so. Now, were you elected anywhere? Are you an elected member?
we are member of the, we are members, Lordship, of the Pharmacy Council. Amongst us, members are selected to the board. Telling him the-
You are who? No, you are not a member of here. You and three are
You're the
members
Indian
of the
Lordship,
petitioner
so
number one.
that's all.
No, that is understood. My question is whether you are a member who have been elected.
No, Lordship, what do you call it, represent the collective interest of the registered pharmacists of the state of Assam.
Now, how are you concerned?
Lordship, it concerns us, Lordship, because our members go to the Pharmacy Council. Your Lordship.
Yes, Mr. Chaudhary. Causing difficulty to your junior.
No, you also kindly take up this matter second. I haven't actually didn't go through it.
Okay.
Or
So there is
maybe,
an
or
interim
maybe
order.
tomorrow.
No, there is an interim order.
Ah.
So therefore, we'll take it up at 2 o'clock. We'll look into it because you see the interim order says that not to take any major financial decisions. Now, major financial decisions, first of all, are you members? Are you members who were there present? Because could you have been at all a participant in the said meeting?
Yes, I think we could.
No. You could
No,
not
we
have.
are pharmacists, my lord.
You are pharmacists, it's okay. I'm not on that. You are pharmacy council, all these things is okay. My question is, could you have been a part of this? You are therefore saying that if this meeting would have been called by a registrar, he would have selected amongst these people who are present somebody else. Those persons who are there, they have no grievance. You have somebody else. My question is this, as to how you have, because you are now,
Because
you have got
actually,
an interim order to the
I haven't
effect.
gone through the files, possibly kindly take it up at 3 o'clock. At 2 o'clock, item number one matter is fixed in court number 3 o'clock.
3 o'clock.
I'll take it.
I'm only
I'll go through-
looking
I'll go
into it.
through it.
Only that aspect.
Yes.
That whether this interim order is there, because this interim order has the effect of not allowing them to function properly.
Proper.
It may, if you could have been a part of that meeting, it's a different thing.
Anyway, I'll go through it.
May I please,
What is this?
This is actually, there was a WPC number 544521010.
Be corrected and updated by substituting the name of the deceased demand which is legal. So it's a case of substitution.
No, yeah, it's not question. Now what happened is that WPC 544521010, when it was filed, one review petition was also filed, 67/20112. Now
Why a 2010 petition is not disposed of till now?
Yeah. The thing is that there was an order in 2012 actually, which was not met as of right now actually. So,
Grievance of a petitioner in the present writ petition is the respond number 5 to 13 were allowed to occupy the patta land belonging to the writ petitioner without initiating any proceedings either for acquisition or remand in the revenue disaster management so and so. My goodness, where did this file got lost? After issuance of notice, why? How did it happen? Directing the respondents first to consider whether the land is declared to be public property mentioned. So the petition is disposed of.
The petition has been disposed of with
Now
the
what do you want?
direction. Now, what we want is that the legal has a filing to IAS because that order was not complied with. Now the thing is that when we went to file that IA actually, the name of the legal has, though it was order was passed and it was uploaded in the same WPC number 5445, it was not uploaded actually. The order is there. It is in page number 10
Of
of IA number 1913, which is
no. My question is how, in respect to a matter which has been disposed of,
yes.
I can substitute. Under what provision?
What I'm going to say to this lordship is that in this WPC actually one review application was also done.
I've seen that. This is
And
Suman
in
Khan's
the
order.
review application, the legal heirs of the defendant, who was the plaintiff, who was the petitioner in WPC,
Hmm.
they were substituted.
Hmm.
And that order has been uploaded in WPC 5445 only.
Hmm.
Now the thing is that when we have filed two numbers of IA, one is a condonation of delay, and one is that order was not complied with actually. Then this came to the matter in the registry that this legal has not been uploaded in the system or whatsoever. So for that we have to file an IA. So we are filing an IA for that purpose.
How can that corresponding correction will be there in that writ petition? You see, Mr. Counsel, writ petition was filed by your father.
Yes, fine.
After it was filed, it was disposed of
Yes.
by the judgment in the year 2012. Review was sought for. In that review, as your father expired, all your names were brought in.
Yeah.
So their names duly appear in the cause title of the review.
Yes.
Now you want that this cause title should also reflect in that writ petition which has been disposed of.
Yes.
How is it possible?
No.
No, Mr. Counsel, that is not possible for the simple reason that when this happened in 2012, the writ petition was disposed of, your father was alive.
Yes.
So when your father was alive, I can't put it now and say that he was dead at that point of time.
But this WBC, this subscription was done in 2015.
Understood. But when it was review was filed, if the review would have been allowed, the question would have been different.
Yes.
The writ petition would have been brought into picture.
Yes.
But no, review was disposed of,
Disposed of, yes.
saying that, okay, this particular person who had filed a review, he can file a suit.
Okay.
That is what has been mentioned.
Yes, got it.
So there in the review, your name is there.
Yes.
But how can I direct your name to be put out here in the writ petition, which is not finished?
But then I could pray for this lordship is that to grant me a leave so that I can bring this in the WPC, the Substitution of the,
How is it possible your father was alive when the WPC was disposed of?
that's true, but the
You
order.
do one thing, no, you go get the legal air certificate from the DC. That would. No. Heard Mr. So-and-so, the learned counsel appearing on behalf of the applicant. Mr. So-and-so appears on behalf of the respondent. Revenue RA2, so-and-so appears for a year. So the instant application being misconceived, the same is rejected. Yes. Yes, Mr. Goswami, what is
Well,
this?
an order was passed on 16/12/25, my lord, directing us to specify which persons were holding these offices, my lord, that we have done in this IA.
Now what do you want?
My lord, this should be recorded in the court record, and then if necessary, my lord, we can
What the
rectify the.
respond number 3 is so-and-so and respond number 4 is so-and-so. Now let us see what is happening. It seems to note that both the respondents are claimed to be represented by Ms. Sunday and so-and-so respectively. Unity 3 and 4 are not shown to be represented by any person, which is not considered who should be represented by concerned precedent of so-and-so. So you want the correction of the cause title. In a sense.
Actually, my lord, that is not directed in the order, but if necessary, we can do it, but otherwise, we have given the names. There are 3 in the IA.
No, here you are, no, what the order was passed on that day was that you have respondent number 3 and 4.
Well,
One respondent, Miss Dev is appearing, and other, Mr. Bothakur is appearing. Now, it is the opinion of the learned coordinate bench that these are entities. These are not natural persons. These entities should be represented by natural persons. That is what it is.
Right.
So therefore, now you want that to be, so you have to file an application in that regard.
that I have.
What application is this?
No,
What do you want? You say that so-and-so is, you have to put a cause title properly. You have to ask that this so-and-so is there. Now it may be shown by inserting it or saying, substituting the respond number 3 and 4 as so-and-so represented by so-and-so, so-and-so. You want an amendment to the cause title.
Madam, that is what I have submitted, madam. I followed the order, man. The order doesn't say so. Order says you give the names I have given, but my submission is that.
But
necessary,
no, giving names would not do.
Madam.
You have to insert in the cause title.
Definitely, man.
How do you do it? You have to ask for the amendment of the cause title.
If my oral prayer is accepted, madam, I can do it. Otherwise, I have to file another application.
You have to file that application because that has to be amendment. Nah. This is an amendment to the cause title.
Here, my lord, I have just.
No, you have indicated very well, but you have to file an amendment.
Madam.
Anyways, I'll no. It's okay. He says so, but he has to file an amendment application to amend the cause title. Not this way. You file your objection. Okay. Heard Mr. B.T. Goswami, the learned counsel, appearing on behalf of the instant application of the petitioners. Miss Hindi Union. Miss, who appears for 3? Mr. Bothakur, you appear for? Mr. S. Bothakur, the learned senior counsel, assisted by so-and-so, appears for respond number 3. Miss M. Dev appears on behalf of respond number 4.
Yes.
Both of you together.
That's the problem, Your Lordship.
Again, what has happened?
That's why, Your Lordship, that order has been passed by the Honorable Court.
So both of you are appearing for 3 and 4. But,
Two-
but you have been engaged by somebody else.
Two sets of people are claiming overdose post, Your Lordship. That's the. I have appeared, Your Lordship.
Directing to hand over the possession of the office premises of so and so. And Nehru Park is connected land documents along with vehicle bearing number, registration number, so and so to the petitioner profit. And to direct the official action to ensure the petitioner will function from such office without any hindrance. Who are you, mister?
My lord,
Who are you?
I'm the appointed, that, this is called, my lord. Your lordship will kindly come to page 21. Of the,
Following the union decision, so and so is appointed as the preventive Sanchalak from the Rajya Rashtriya Sankar Committee to have.
then come to my lord, page 23 now.
Following the union decision of the man.
He is respondent 7, my lord. He was removed and my lord, I was brought in, to man that post.
Now you want on the basis of this
Yes, my
to
lord.
hold it.
He is putting a lock, he is occupying the office.
Who?
The respondent number 7, my lord, this dismissed person, my lord, Sujya Bansi Sodhuri.
Now, why? Now, what is this, what is this particular?
Rashtrabhasa.
What is that? Rashtriya
We-
Bhasha
we-
Samiti. Now, what? This is?
It's a registered society, my lord.
Assam Rajya RR. What is this? Assam Rajya Rashtrabhasa Prasar Samiti. What is that?
It's a registered society, my lord, affiliated to the, respondent number 3, my lord. Rashtrabhasa Prachar
Fantastic.
Samiti,
Go to the civil court.
my lord.
Civil court. How can we decide this
My lord-
aspect? No, this is nothing to do. You are saying that you are enjoying. He says that he is enjoying, and both of you don't know who you are appearing for. Huh?
My lord,
What
my
he
lord,
means?
This was, issued on the, consideration that.
No, Mr. Gustami, this is not a correction. That is why.
Functions, my lord.
Not possible. You are claiming on the basis of 3/1/2019 that you are the
Prantiya Sansan.
Prantiya Sanchalak.
Yes, ma'am.
And you have been appointed by the Pradhan Mantri. Pradhan Mantri is for?
Pradhan Mantri Secretary General, my lord, in common parlance. My lord, he is in office now, my lord. This is absolute lie. This is without any basis. My lord,
Give,
I
filed an affidavit, my lord. It supports me, my lord.
I have filed
My lord,
an additional
all
affidavit.
documents are.
who is running it?
So for
Who are you again?
my instruction is, Your Lordship. the Team compromising of Your Lordship, my clients, they are running this, Your Lordship.
But one thing, Mr. Goswami, tell me, why is the Assam Rashtra Bhasha Prasar Samiti not a party?
Assam Rashtrabhasa Prasar Samiti.
Oh, where you are the secretary?
My lord. My lord.
No, it is not. You are asking these people from Warda. I think this must be in Nagpur, na?
Nagpur.
Nagpur. Yes, have something to do with RSS.
No. This is
Then?
very old, man. No, started by Mahatma Gandhi, my lord.
This is by Mahatma Gandhi.
Yes, man. 1936.
Well,
Thereafter, the petitioner society was registered in 1953.
And that body is not here. Where you have been appointed. Who? 7 is also not there.
7 is there.
Who is appearing for 7? You are where? Bihar. No, his address is in Bihar.
That is why he is here, madam. Jorhat address, he was not available, madam.
No, we cannot. Anyway, go to TV.
He was
Take on that.
appointed by the group bureaucracy.
No.
By their
Our
presence.
Mr.
Madam,
Mr.
Purvanchal Mantri is there, madam.
I will therefore
Madam,
say,
Response number 4 is there, madam.
I'm not doing it.
Committee.
And why you are making the central government a party unnecessarily? Jorhat, what does the deputy commissioner have to do?
No. This is under the Directorate of Central Hindi Director, madam.
Where?
We are being financed by Central Hindi Directorate. Madam, this is beyond my record, madam. Very difficult to. You lordship can.
Took notice to some other part. Some other address. Those are written of school.
Then
No, you have to make the branch a party.
Well, I'll make it.
You have not made.
That I'll do.
No, this cannot be done.
That I'll do it.
Who is what? Did not.
Madam, I have made Purvanchal Mantri, madam. There is a Purvanchal Mantri, madam. He is a party, madam. He is above me, madam. He is a party.
But he's in Warda.
No, but he is the Purvanchal Mantri. His office is in Wada. Purvanchal Mantri, madam.
He
That
looks
is his
after-
office.
yeah.
You will appear. You will appear because the running the in this school in the office the income system. You will appear because of the.
In 2024 fresh election held, your lordship, where we got elected, your lordship. To that effect, your lordship, we have filed an additional affidavit.
And Mr. Bhattakur, who has signed your vocal?
With your lordship, respondent number 3, your lordship. his
No, name.
Name, your lordship, Surya Bond.
Madam, your lordship will kindly.
Ramchandra Boitto,
M. Chandra
Boitto,
Ram Singh Buddha
lordship.
Yes, Hamsundar
Ram
Ramsing.
Singh Boitto.
and Prabir Kumar Guho.
Yes, he's a that Purvanchal man.
He was appointed as a Purvanchal Mantri, your lordship.
He is also, you are appearing for him.
Lordship, 3 and 4, your lordship.
These are the persons.
Madam,
And you are appearing for who has signed your vocal?
Secretary of the Nagpur. That's what. And
self-proclaimed.
What has- What has happened, your lordship, in this case, your lordship? Let me sum-
Wait.
What
Let
has
us
happened in
give
this
her.
case, your lordship? These two groups have been fighting for the control of this, your lordship. My group and her. And your lordship, in 2018, there is an election, in which election we won the election, but Security Commissioner, as required under law, your lordship, has not given charge report. Then, your lordship, we filed an appeal. Appeal is presently pending. And in the meanwhile, in 2024, your lordship, a fresh election was conducted, and in that election, we got elected, your lordship, and thereafter they have also challenged that before the Charity Commissioner, that disputes are going on. But
Before
as
the Charity Commission.
Charity Commissioner is
Under the Trust Act,
Under
Maharashtra
the
Trust
Trust
Act.
Act, your lordship.
There.
Lordship there.
What?
That
Okay,
is the
so they
position.
have challenged it, this is disputed,
Lordship.
both of you.
Both disputed.
All of your cases are disputed, who is what.
Lordship.
Now he is your man.
He is mine.
So
She is my man, your lordship. We appointed her, your lordship.
so you appointed him.
And she appointed, our client appointed respondent number 7 earlier.
Okay, so therefore, the question is, you appointed respondent number 7. As per your, no, No, madam, your society. Okay, your trust have appointed respondent number 7. Who has appointed him? Who has appointed him? They have elected him. And you have appointed him.
And her case, your lordship, is this, your lordship, that Assam Rashtravalsa Pradhar Samiti is an independent society. It has nothing to do with the water. That is what she has said, your lordship. And our case,
And both of your cases
lordship,
are pending before the,
charity commissioner, your lordship, there
right,
at Maharashtra, your lordship.
Charity Commission. I'll relegate the petitioner to go and fight them.
No, charity commissioner cannot, your lordship, he cannot approve. Charity commissioner, it is only on respect of your lordship, election and trust, members of the trust. So first.
So therefore, the fight between both of you,
Lordship,
and he is the person who is fighting a proceedings here
lordship.
on behalf of both of you.
No, your lordship, she has an independent cause of action, your lordship.
No, his independent cause of action arises because you have appointed him.
Yes, your lordship, now your lordship.
And they deny his appointment to him.
Now your lordship.
So that this, because of both of your disputes,
Lordship.
he is here.
No, your lordship.
And how can this court decide this? Because
that's-
both of you are disputing.
No, your lordship will kindly see that your case is that, your lordship, the deputy commissioner is not taking action against, on her representation, your lordship. That's the case, your lordship. And
No, why will the deputy commissioner take action?
that is an issue, your lordship will have to take action.
No, why? Why will the deputy commissioner come into the scene?
No, your lordship, that's an issue, your lordship will have to take call on it.
Somebody is illegally.
No, my question is, no, because he is your proxy.
No, not proxy, your lordship. No question of proxy, your lordship.
No, he's your man.
Lordship.
So therefore, I'm therefore asking you, why the deputy commissioner should take action on him?
That is your lordship, for your lordship to take a call.
Because
That's
your
it.
lordship will-
Because your lordship will kindly say, notice was issued, I received, I appeared, and on instruction, I filed the affidavit. My role ends there, your lordship.
No,
My lord,
Lord,
your
Mr.
lordship,
BD.
my lord, kindly come.
I'm dismissing your
No,
petition.
Page
please.
182, man.
No,
Page 182, may kindly be seen, man. Even the directorate, my lord, writes to me, Central Hindi Directorate, letter, my lord, 182. Page.
it is in Hindi.
No, my lord, they prepays, my lord. 181.
With respect to the land directed to state that the grants under the scheme for financial aid, so and so that. Okay, no. Heard Mr. B.D. Goswami, the learned counsel appearing on behalf of the petitioner. Union? No union. Full stop. Mr. S. Thakur, assisted by Soens, the learned senior counsel, assisted by so-and-so, appears for the respondent number 3 and 4. Miss M.D., the learned counsel, also claims that she appears on behalf of the respondent number 3 and 4. Full stop. Higher education? You are there. Okay. Ms. P.R. Mohanto appears on behalf of the respondent number 5. Mr. J. Hendig appears for the respondent number 6, and Mr. So-and-so appears for the respondent number 7. At the outset, it is very pertinent to take note of the reason as to why Mr. S. Thakur, the learned senior counsel, claims to be appearing on behalf of the respondent number 3 and 4, and Miss M.D., the learned counsel, claiming to appear on behalf of the respondent number 3 and 4. The respondent number 3 and 4 are societies, na? The respondent number 3 is a trust. This trust, a group of members claims that they are managing the affairs of the trust. And from their group, the respondent number 4 have been appointed. Whereas there is another group who also claims that they are managing the affairs of the respondent number 3. And from their group, the respondent, that one of such members is the Purbanchal Mantri, is the respondent number 4. It is for that reason Mr. S. Bhottakur is representing one faction and Miss M. Dev appears for the other faction of the same party. It is also very relevant to take note of that one faction, which is for whom Mr. S. Bhottakur appears, have appointed the petitioner as the Prantiya Sanchala. What is that?
And a state head.
Prantiya Sanchala. Whereas it is the contention of Miss M. Dev that the trust have appointed. What is there again? Another society. You are appealing for a trust. There is no any. Who are you? Wait. Who has appointed you? Huh? So you say that you have been appointed by respondent number 3. Whereas the respondent number 7 claimed that he is the Prasar Prantiya Sanchala of the Assam Rajya Rashtrabhasha Prasar Samiti, which is a part of, which is a unit of the respondent number 3. The grievance for which the petitioner has approached this court is that the petitioner, the respondent number 7, was dismissed from the post of Prantiya Sanchala by the respondent number 3, by the respondent number 4. By whom? By the respondent number 3.
By the respondent number 3, man.
And the petitioner was appointed by the separate order on 3/1/2019 as the Prantiya Sanchala. It is the further grievance of the petitioner that the respondent number 7 have not vacated the office, and the petitioner, and as such, the petitioner is not being able to discharge his duties for which the instant writ petition has been filed. This court have also taken note of that various affidavits have been filed by the respondent number 3 and 4, whose person is Priyanka Das, whose junior is Priyanka Das. Priyanka Das is whose junior? Priyanka Dev, your junior. By the faction for which, by the respondent number 3 and 4, by the faction, by the respondent number 4, the faction of which is being represented by Miss M. Dev. The respondent number 7 have also filed an affidavit in opposition From the materials on record, it is very clear.
I have replied to that. Matter.
Replies thereagainst have also been filed by the petitioners. From the materials on record, it is very clear that there are disputes as to who actually represents the respondent number 3 and 4. There are disputes as to whether the entitled faction of the respondent number 4 had appointed the petitioner or not. It may not also be out of place to mention that the learned senior counsel, Mr. S. Potakur, appearing for one faction of the respondent number 3 and 4, and Miss M. Dev, the learned counsel who appears on behalf of the other faction of the respondent representing the respondent number 3 and 4, also admit that as to who presently is in charge of the management of the respondent number 3 is presently pending before the charity commissioner. Huh? Joint Serenity Commissioner, who has his office at Wardha, Maharashtra. Who's taking into account all these disputed questions, it is the opinion of this court that the jurisdiction under Article 2 to 6 of the Constitution cannot be exercised unless and until there is a clear decision on the part of the Joint Charity Commissioner. From the Joint Charity Commissioner as to who actually is managing the affairs of the respondent number 3. Accordingly, this court therefore closes the instant petition, thereby granting liberty to the petitioner to approach the competent authority upon such decision taken by the Joint Charity Commissioner before whom the question is pending as to who is actually managing the affairs of the respondent number 3.
Good night.
What's all?
Yes, what is this?
May it please your lordship. Lordship, the IA is filed pertaining to the
Same order,
lordship
same case.
in a similar matter only, but the writ petition number, the connected writ petition along with another writ petition being writ petition number 451925 were mentioned to be withdrawn, your lordship. And on 26/5/2026, both the matters were listed for withdrawal as consecutive matters, your lordship. The prayer were made for withdrawal along with liberty to refile the same. But in one of them, inadvertently, your lordship, the liberty part was not there, your lordship.
Which one?
Lordship, this connected writ petition, the 6477/2022. And thereby inadvertently it was withdrawn without having the liberty.
Direct this matter to be listed before that judge, no?
Lordship,
I think these are the two petitions, no?
Lordship.
4519.
yes, your lordship.
Their liberty was granted.
4519 was granted, but the 6477 was not granted, your lordship. Although
are
both were
connected.
prayed at the same time, your lordship.
Both are connected.
Not connected, your lordship, but similarly situated matter, and both were being withdrawn because of the same reason, your lordship.
No, I think let this matter be listed before that judge.
Lordship,
Taking into account the relief taking into account the prayer which have been the relief sought for in the instant application. List the matter before. It is the opinion of this court that the matter be taken up by the judge, by the learned coordinate bench who passed the order dated 26/5/2026 in WPC number.
6477 of 2022.
So and so. Full stop. Accordingly, the registry shall list the instant application before Justice Anjan Moni Polita. Before the bench of we have a line to it.
Highly obliged, Your Lord.
In this case, madam, we were projected as a petitioner in the contempt petition.
Huh?
We were projected as a petitioner in the contempt petition. However, we were not the parties, madam. Our signature was put by fraudulently on copy number
Where
one.
criminal proceedings should not be initiated against opposite for fraudulently project the against the petitioner's. Who is this?
We were, my lord, projected as a petitioner in the contempt petition.
Opposite party number one is
Who is my lord? Abdul Sattar.
what did he do?
He, my lord. Kindly see, my lord. Para 2, ma'am.
As to why the applicants dragged into contempt petition.
We had not put any signature in the Ukalatnama.
Matter pertains to allotment of land, my lord. Petitioner, they are residing in the government land, my lord. They applied for allotment of land and the matter was processed, my lord. Thereafter, they came to the court, my lord, and this will go direct the authorities to decide there, my lord, regarding the allotment of land after inquiry, my lord. Thereafter, my lord, the body, my lord, the subdivision land authority body, my lord, meeting was held. Some petitioner already allowed, my lord, already recommended for allotment. Now they are saying, my lord, they did not file the, my lord, case, my lord. Now, they inviting themselves in trouble, my lord.
My lord, we never was the parties in the
They are
writ petition.
residing in government land, my lord.
We never was the parties in the writ petition, not in
I
the
will take
contempt,
instruction, I will file affidavit, my lord.
not in,
I will take instruction, I will file affidavit. I already
For
sent.
whom are you appearing?
I am for opposite party number one, my lord.
Huh?
I am appearing for entire all petitions.
So you are appearing
For all the petitions.
also for the applicants.
Yes.
projected. However, we are not the parties in the writ petition,
See, my lord,
not in the contempt petition.
they are beneficiary of the order, my lord. It is not that they.
What
order
happened, my
passed
lord?
against them, my lord.
While making an inquiry,
Okay, good. We should ask him to file a.
They are beneficiary of the order, my lord. They are beneficiary of the
now,
order.
my lord, forcibly they made me beneficiary, we were not the beneficiary.
Kindly see, my lord, they are residing in government land.
Pursuant to the order of this. writ petition.
Understood, but he is now
Yes,
now the question arises that who is actually appearing for the applicants?
yes.
If you are appearing for the contemner.
Yes.
Yeah.
Yes.
These contemners are also the applicants here. He is appearing.
4%, 5%. Out of
66.
65%.
Ah. Here, how many applicants are here?
Five
Only
applicants.
5%.
So they say that they were never party.
Never with the parties of the writ petition as well as the contempt petition. There
So
somebody.
these 5%.
Yes,
Yes.
So these 5% are also petitioners here.
Yes, yes.
The issue notice making it returnable on 10th of August 2026. Mr. So-and-so accepts notice on behalf of the respondent number,
One month. Opposite party number one. In this side.
opposite party number 1. Why you are making the other people a party? They have no business out there.
Because they were the pro forma parties, because they were the.
No, we don't issue notice upon 2 and 3.
Mark.
Issue notice upon the respondent number 1. Returnable on so-and-so. Mr. So-and-so accepts notice on behalf of the respondent number 1. And submits that you would like to file an objection to liberty granted to the respondent number 1 to bring on record their objection on or before 5th of August 2026. This court is not inclined to issue notice in the instant application upon the respondent of opposite party number 2 and 3. Right. Yes, Mr. Moto.
My lord, actually, I am challenging the action of the respondent number 1 and 2.
Who has filed for modification? For that matter. This matter has to be finally disposed of. That day I wanted to dismiss it as somebody report. This, the main report. Yes. Argue this. That
Hello.
day, on that day, I did not, he asked
Yes,
for
regarding
time.
point of
He said
jurisdiction.
that let my sin dismiss in the hands of my senior.
No, my lord, the regarding point of jurisdiction, that is, my lord, maintainability.
Yes, what are you challenging?
I'm,
I-
no, I am the challenging, your lordship kindly see the my land, I am the one of the co-potter that our land is occupied by the Oil India without following any proper procedure of law. So my pair before this honorable court, that my lord, by following proper procedure of law, you giving the compensation the rightful owner. That is my pair now. But your lordship kindly see there is a act called, my lord, regarding acquisition, there is a act.
Oh, yes. Now I can. You are one of that is, you are one of the key states. Key state,
Hatang Pani, I am the one the co-owner.
you are a co-owner. You have a right to claim a compensation.
My lord.
Who there? As per the Petroleum Act, there is a provision of the section 6 or 7.
Exactly, my. They have acquired the land. My grievance is your lordship kindly see what is my pair. My pair is then my lord Oil India Authority. They acquired it and they laid on the pipeline without following any proper law, my lord. There is
Have you
acquisition law.
not taken the steps? Hey, uncomfortable. Huh? You are doing it under the Petroleum Act.
And next step with the owner and ask the buyer, and we are agreed to pay,
Then
agreed to pay the tax. Now thereafter, all of this is due. They need to come. And it is like,
To whom?
yes, correct. Now, friend,
and who are you? How is the T state filing a petition?
No, I am the one of the my lord
Now,
co-owner.
how is the T state a
T state, my
juristic
lord,
persons? You
Without
tell
my
me.
lord, because that entire land in the name of.
No, Mr. Counsel, how else T state will be a juristic person?
That's why I'm not respond number 2 is there. Petition number 2 is also there, my lord.
Petitioner number 2 is that person. So
My-
we are only in respect to a shareholder.
My lord. No, not he's a recorded pata there of the.
He's a recorded pattern. So you will have a right for
My
that
lord.
right.
My lord.
Get the money where, why the petition?
That's why, my lord, I'm submitting, my lord.
Ah.
Your lordship kindly see what. No, that's why your lordship kindly, that my lord, that by some, my lord, they cannot say, possess the
Eh?
land, my lord. No, my lord, your lordship, see my pair, my lord.
Why today all matters are all these disputed questions of facts are coming.
No, your lordship kindly see my pair. And
Where Priyanka here?
Priyanka, your lordship will find at place 70 top bottom. Place 270 bottom, Priyanka motorcycle.
Ah,
And the power of attorney is at page 250 of Priyanka Bhattacharya because it has been entered
250.
250. 250 is the power of attorney given by Priyanka Bhattacharya to one Babul Sonowal. And accordingly, Babul Sonowal, on behalf of 27 of the co-owners, have entered into an agreement to sell with us.
Now, are you denying this document?
yes, my lord, your
No,
lordship.
there is no
No,
denial.
my lord, before that they have paid money, my lord.
There is no.
This is a
Whatever
24.
may be.
No, this is 24th agreement. This is 24th. They have paid in 2022, my lord.
My question is, yeah, this is an agreement for sale.
My lord.
Yes.
Now, in this agreement for sale, you are a party.
Yes, my lord.
There's no quarrel
No,
with
my
that.
lord, they denied that, my lord.
So you are a party. So this, if you have any amount to be claimed on the basis, if
No,
there is
I'm
a
not.
violation, no, if it is a violation,
My lord.
civil suit.
My lord, your lord.
Why will this court exercise 226 again here?
No, my lord, your lordship kindly see before, they are not doing their part, my lord. Your lordship kindly.
Understood. You are trying to enforce an agreement out here. 2 to 6. Specific
my lord, because
performance.
they are just taking the authority, they have not complied with the rules and procedure, my lord.
What is the rule? You have gone for an agreement for
No, my
saying
lord, that is
no.
disputed, my lord.
No,
Since it is disputed,
if
No, your
it is-
lordship,
if it is, no,
your
the,
lordship kindly
Mr. Mohanta, if it is disputed, division, civil court.
And
If it is not disputed, then also civil
Lordship
court.
will kindly see the prayer in the writ petition. The prayer is only for money, payment of money, not
Yeah.
regarding this
No,
This
these are
particular
the-
act
this
of
is- this is
1962.
Why I am looking the whole day. with
page
civil-
18. The prayer is only for payment of the compensation to him or to her.
If you don't go.
no, I am not paying for,
Not,
may I,
not
your
regarding
lordship.
adherence to of any rules or
Your
anything.
You are
lordship
praying
kind-
for?
No, your lordship kindly see, my lord.
Page
My-
18.
Ah.
Lordship will see the
18.
prayers first.
You are
prayer
paying
is
for
page
whom?
18.
You declared a petitioner. What petitioner?
No, my lord, you're eating the Neshara Mandam.
First of all, why did you file in the name of the estate?
No, I'm, because my lord, your lordship kindly entire land in my lord.
No, you cannot. You are a part of the own. That is, it is a. You have a land which has been. You are a part owner of a particular land, which all these lands together form a estate.
My lord.
The estate is not a juristic person.
All right, even then, my lord.
So one is gone.
Well,
So you are two.
Two,
Two is becomes one.
one, which is a one
Now,
because
two- if the one has, the two becomes one, the one, that petitioner's claim is in respect to the amount which has been agreed out there in the agreement for sale.
7 crores.
That's your lordship kindly see the page 24, kindly, my lord. Your lord page 24.
Page?
Page 24. Page 24 of my writ petition.
Yes.
That is a letter by the my lord. Your lordship kindly see clause 3, my lord.
Okay, expert practice presently only survey has been disbursed as regards other.
Compensation like venue, etc.
Value equipment, the same shall be paid.
All are relevant land document established upon existing registered sales deed. Once the all relevant land documents are the value, the same shall be paid to the recorded patadar. That has not been done, my lord. So let them comply with that, my lord. What they have stated, your lordship, and the same shall be paid to the recorded patadar.
No, you see para 2. The surface compensation amount of rupees so and so was disbursed against land measuring so and so under the occupation of area represented by so and so Sunwal and duly confirmed by guardian manager so and so. Meaning that your power of attorney have received this amount.
No, my lord. That's
He
since
has
there is a
before-
dispute, my
no,
lord. They have
he-
to refer it, my lord. Or
No,
FIR also.
No, he. is
Because
not
that we
before
have
this court.
disputed this document, my lord.
This court is a, this type of litigation cannot be. You have given a power of attorney. When did you give? 23. And you're therefore the question is that you have to ask that particular person when your name of your power of attorney. Who is Priyanka Chakraborty?
Page 250 Lordship looking at.
That I'm seeing. Now, whether the power of attorney has also been given by here.
Page 252 Lordship will see Priyanka Bhattacharya giving a power of attorney to Babul Sonowan.
It is of 6th of December. Go and ask Babul. He has received the money. Go and ask him. Priyanka was a daughter of Uday Guti.
Oil has paid 3 amounts till now. One is the surface compensation of 94 lakhs. That is
94
based-
lakhs, huh?
Okay.
Not 4.
The crores come thereafter. First is 94 lakhs, service compensation. Then comes 7 crore. Then comes 7 crore as a rehabilitation grant. And thereafter, 3 crores 50 lakhs 61,000 as a part of the sale deed, agreement to sales, agreed amount 50%. These are the amount that has been paid. And there are multiple people who are involved and who are claiming a share of this amount. Therefore, maybe the other day I say that this is a civil dispute.
Pure.
My lord, your lordship
And
can
the
see
claim
what
is
they are
basically
doing.
money. They are
Release to
taking care
an
of the
unauthorized
money.
person, they are after, my lord, with some
Not
people, my
unauthorized.
lord.
I can show those documents also.
That agreement is after releasing the money, my lord, releasing someone else, thereafter they have.
So therefore, you have not got the amount or part of the surface concern. If you have
No,
not
when-
got if you have not got, somebody else have got it.
No, not yet released, not yet released.
94 lakhs have been released.
That has been
94,
released.
7 crores
That has
and
been-
3.
Have you got the part of 94 or not?
No, my lord.
So
No,
who is, somebody has not given you. Somebody fraudulently has taken it.
No, when we made a complaint to them, my lord, they should have referred to their, my lord, they have not done it, my lord.
You have entered into an agreement. Why did you enter
That
into an agreement?
Later on. in the-
Amount was
I am
paid in the
denied.
year, no, Mr.
No, I am denied
Amount
denying
was paid in the year 2022.
22, but that
So
agreement,
then in 2023, you still entered into an agreement. Why? Why did you enter
no,
into an
that, my
agreement?
lord, regarding that, my lord, there is a FIR also lost, my lord. FIR was filed, we deny it, my lord. Some person.
Who has filed an FIR?
FIR is filed by the, very interestingly, your lordship kindly see, respondent number filed, my lord. Here,
FIR was filed by Bikram Sharma, another co-owner who had withdrawn that.
no,
FIR.
he has not withdrawn the account. He has, my lord, he has filed a writ petition also here. He got a stay order from writ petition here also.
Where is that?
And
That is, my lord, that is been withdrawn, my lord, surprising, my lord.
So we are
That
arguing
is
for
withdrawn.
someone who is not before his honor.
Then, my lord, that I,
Let me come back at 2, get more energy after having food.
my lord, I'm. if your
No,
lordship-
after food,
if
and
your-
then I'll dismiss your petition.
Point of, my lord,
No,
deliverability,
this
I'm.
petition cannot, this type of petitions cannot. Today, I'm getting
No,
this, this is the 7th petition.
Then
Okay.
all like your lordship kindly, if your lord, no, my submission
Court,
for their
civil
state
court.
authority, why they have not applied their rules, my lord? Why they have not gone for their rules?
Why did you enter into an agreement for sale?
Afterward, my lord, after requisition has been done. that
There's
is
no
after-
requisition done. There's
They
no
have-
requisition.
They have paid.
We have taken possession of the land. An agreement has been signed. Agreement is registered. He is a party to the agreement. Now we are
That
waiting
is
for a
not-
sale deed. There is a dispute between them and we are not able to execute the sale deed. This is where we stand today. After paying around 10 crores of money today. Now it's a fight between them.
You have not got a single penny.
Probably not getting, my lord. That's why, my lord, your lordship kindly see, even the person who filed this petition
34
before this
lakhs is
honorable
what
court.
he has got is what the instructions coming from.
Huh?
34 lakhs they have got till.
Who are you?
One of the co-owners.
You are the intending purchaser of the figure. You and them. And let me come.
No, sir, can I, let's say at 2:30, I have a matter at port number 1. SC is appearing from Supreme Court of Calcutta.
Okay.
2:30.
230.
Item 1 of Quina Bells to video conference.
Yes, Mr. Counsel, who is appearing in this matter? Can't hear you. Your voice is not coming.
Am I audible, my lord?
Yes.
Yes. My lord, this instant IA is filed under section 151 of the CPC, praying for recalling the order dated 29/11/2022, passed in WBC 221 of 2019, which was obtained by the petitioner by playing fraud, my lord.
So you admit, Mr. Counsel for the petitioner,
Lordship, yes. Yes, I
you
agree.
admit to the fact that the person died on
10/7/2011.
10/7/2011.
Yes, Lordship. However, it
Then we have
was,
to recall this order.
Lordship, however, it was not intentional. It was a clerical oversight.
You- Where is the judgment?
My lord, the judgment is at page number
Which you have sought for recall,
93.
page
93.
23,
Page 93.
93.
93. Annexure H.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the applicant, oblique the state of Nagaland. On behalf of the state of Nagaland. And Mr. So-and-so, who appears on behalf of the opposite party. So-and-so appears on behalf of the applicants, and so-and-so who appears on behalf of the opposite party number 1. This is an application filed by the petitioner, by the applicant seeking a recall to the judgment and order dated 29/11/2022, passed in WPC number 221/2019, whereby this court taking into account that the husband of the petitioner expired on 28/1/2008. Have directed, had observed that the dismissal of the petition, the opposite party's husband by an order dated 23/2008 was bad in law and accordingly was set aside and quashed. This court further directed the respondent authorities, the applicants herein who were the respondents in the writ petition, to grant all pensionary benefits and other service benefits to the opposite party number 1 herein, as per the existing rules with effect from the date of death of her husband, of the husband of the opposite party, that is 28/1/2008. The records further reveal that upon inquiry being made, it could be learned that the husband of the opposite party number 1 expired on 10/7/2011, and in that regard, the certificate of death issued by the Sakhi SHAKI Baptist Church, as well as the memorial stone over the grave of the husband of the opposite party number 1, wherein also it is inscribed that the husband of the opposite party expired on 10/7/2011, was placed before this court. This court also takes note of that pursuant to the notice issued on 25/5/2026 in the instant application, an affidavit in opposition has been filed by the opposite party number 1, wherein it is admitted that the husband of the petitioner, opposite party number 1, expired on 10/7/2011. In that view of the matter, it is the opinion of this court that based upon a fraudulent certificate which was placed before this court while passing the judgment and order dated so and so, this court allowed the writ petition and passed consequential directions for pension. It is settled law that fraud vitiates all proceedings. As it was a fraud committed upon this court, it is the duty of this court also. This court is under an obligation that based upon a fraud, no relief is under an obligation to correct the error which have been committed by this court on account of a fraud being committed upon this court. Accordingly, this court therefore recalls the judgment and order dated 29/11/2022, passed in WPC number 221/2019. The instant interlocutory application accordingly stands allowed. The writ petition, in view of the recalling of the order dated 29/11/2020, judgment and order dated 29/11/2022, passed in WPC number 221/2019, the writ petition is restored back to the file of the court, and the same be heard by the appropriate bench. I stance disposed. Writ petition on panat likhibo. List the matter before the appropriate bench and list the matter for hearing. It had come up for admission or hearing. And in view of the order passed in so and so, I number so and so, list this writ petition for admission or hearing.
Well, it may be a list for admission. So
Huh?
that if I may be allowed to file an additional affidavit enclosing those.
It's okay.
reports.
We'll for admission, huh? List this writ petition for admission. Before the, in the appropriate bench. Yes, what is your case?
Here we have the Pollution Control Board has withdrawn a consent to operate, your lordship, without giving me any notice. The petitioner is a brick kiln who has wanted to establish a brick kiln unit, your lordship.
You have been, who are you?
I am, your lordship, the person who wanted to establish this brick kiln, your lordship.
Hmm.
Consent to operate was given, your lordship.
Where is that?
That, your lordship, will page 57, your lordship. will be.
Then
your lordship, there are
consent to establish, not
No.
operate.
not operate, consent to operate, no, consent to establish. And accordingly, I establish, your lordship. Before I get the consent to operate, your lordship may kindly come to page 83. This is the closure notice, your lordship. And this is without notice, your lordship. On the basis of certain complaints, your lordship. They said they have visited, your lordship, but your lordship, we have not been informed, your lordship, about this. Now, your lordship will kindly come to page 93 for a moment, your lordship. In fact, this is at the behest of certain brick kiln units, your lordship, which are illegal without any permission. That has been apparent from the page 93 letter. Page section 2 letter. Oh, yeah, please. Consent to consent. Then your lordship, this has happened. There is a joint verification report, your lordship. But matter, they have not taken any decision, your lordship. This is pending as such. Then I came before this honorable court, your lordship. And they have admitted in their affidavit, the pollution control board, that without issuing any show cause notice, this has been,
Where is the affidavit?
that their affidavit is there. Page 103 to 107 is their affidavit. your lordship. And in para 14, they have categorically stated that
Okay.
now,
Mr.
your
Burwa?
lordship, say under section 21 itself, your lordship.
No,
This
not
is-
necessary.
Yes.
As regards issuance of notice that has been.
First of all, when you issue the consent to establish.
Yes.
You need to take note of that it is within the distance of 300 meters from another bakery.
That is very true, because I have also consulted with the officials who were conducting the inquiry prior to issuing of the consent. Because ultimately those parameters have to be checked before issuing a consent. So that they have admitted, there was some lapses, and already as per even my statement may be noted at that moment. Because they have told that already they are in the process of reconsidering the applications that the petitioner has submitted.
That was long time back.
That was long time back, but
Now because of the court is taking it up, you are
now it has come to the light. They are taking much indulgence with the. So at least a
Dear
new.
Mr. Wattago, fixing the matter too helps.
Lords, that's true. your lords.
Yes?
Absolutely. If they reconsider.
In fact, I remember this type of thing earlier. There was a matter which I did long time back. It was a matter pertaining to, I was assisting Mr. Nilodatta Senior Advocate. Hope to do something. You must be seeing out there in nearby Gharapur.
Calcinate petroleum.
Huh?
Calcinate petroleum for CPCS.
Near the Girjananda University. There was
Yes,
two
yes.
cooks. So here the chairman was some PC doctor or something like that. No? So somebody gives a complaint, he just says, okay, cancel.
The reason I was there.
Huh?
I remember those cases because
Ah.
there was a series of such scope plants who have been closed in a day's time. Because of some public complaints that has erupted.
No, you have not,
To
because
neutralize
you,
this-
after consent to establish, you have to give a consent to
Operate.
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 You have not given the
No,
consent
we
to
haven't.
operate.
We have.
Then under such circumstances, what was the hastiness on your part to close it, to cancel it? You may not give the consent to operate in a different,
That's different.
but what is this consent to? You are cancelling it. You are cancelling it to show that, okay, we made some mistakes at that point of time. And now therefore, we say that we cancel it. That cannot be a thing because obviously you will have a civil case against you to the effect that damages. Unless
Damages,
if you had not given the consent to establish, he would not have established it by spending huge amounts of money.
The sizable amount is spent after that. So let us re-evaluate the situation in fact.
Reevaluate or should I set aside this type of?
No, instead of setting aside, because ultimately it was, that is.
They
what my-
reconsider it, your lordship, I have not waited. I have waited
That is what I have been suggested with.
another
the
15
petitioner
days,
also should
20
not be
days, I can
prejudiced.
wait. If they reconsider it.
Should I keep it as Patha, then things
Lords,
would- huh?
lordship may keep it as.
Then it would have some
Lord,
impact.
lordship.
Or else, there would be a pressure created. In fact, the matter may be taken up after a month's time. In the meantime,
Lords.
Let me note down the
Lord.
order so that we point it out to them. Heard Mr. So-and-so, the learned senior counsel assisted by so-and-so. Environment, who appears? Mr. D. Gogoi appears on behalf of the respondent number 1. Mr. S. Bulwa appears on behalf of the respondent number 2, 3, and 4. And Mr. N. Gusami appears for respondent number 5 and 6. The present writ petition has been filed challenging the order dated 3/5/2024, whereby the respondent number 2, respondent number 3, whereby the respondent number 3 on behalf of the respondent number 2 issued the closure notice under section 5 of the Environment Protection Act in 1986, read with section 31 capital A of the Air Prevention and Control of Pollution Act 1981. The brief facts of the present case as it emerge is that the petitioner herein had filed an application before the respondent number 2 for seeking the consent to establish under section 21 of the Air Prevention and Control of Pollution Act 1981 and the rules framed therein under. In the said application, the petitioner categorically mentioned the type and category of the project, the cost of the project, as well as all details which are otherwise required in terms with there's a Blick Clean order now. What is that name? In terms with?
The Assam Brick Clean Establishment Regulation Rules 2013.
You have it?
Yes, sir.
That is not a standard notification, it's only a guideline for the.
That happens to be your basis. That is when as well as the compliance to the Assam Brick Clean Establishment and Regulation Rules 2013. Based upon the said application, the petitioner was issued the consent to establish by the respondent number 2 by an order dated 23/2/2024. With a specific stipulation to that effect, that the consent to establish shall be valid till the date of commissioning of the unit or 5 years, whichever is earlier. On the basis of the said consent to establish, the petitioner set up the Brick Clean by spending huge amounts of money. In that regard, photographs to the effect of the petitioner's bricklane have been enclosed as Annexure 13 series to the writ petition. Did you complete it? To the shock and surprise of the petitioner, on 3rd of May 2024, the impugned order was passed by the chairman, by the respondent number 3 in favor, by the respondent number 3, stating inter alia that when the PCVA officials visited the petitioner's unit on 6/4/2024 and found that the petitioner's bricklane was within 300 meters distance from an existing bricklane in the name and style of MS NBI Brick Industry, and there were 5-6 houses within 200 meters from the Chimney and Kolyabari ME School, which is located at 600 meters away from the petitioner's unit. It is on the basis thereof, without granting the petitioner any opportunity for hearing, the consent to establish which was issued to the petitioner was cancelled. It is on the basis thereof the petitioner, being aggrieved, had approached this court by filing the writ petition. It may not be out of place to mention that the petitioner, before approaching this court, have also submitted representation to the respondent number 3 as well as to the district commissioner, Kamrup at Aminga, along with all details to show that the petitioner all details to show that the basis on which the impugned communication was issued on so and so on 3rd May 2024 it's not correct, in as much as the school in question is located at a distance of around 2/3 kilometers from the constructed unit. It was also mentioned that the bricklane industry, which had been mentioned in the impugned order, is located at a distance of around 300 meters, and the said bricklane industry is running without any valid permission or documents. The said representations were also not considered, for which the petitioner had to approach this court. The record reveals that this court, by an order dated 11/11/2024, issued notice This court have also taken note of the affidavit which have been filed by the respondent number 6. By the respondent number 2, 3, and 4. Wherein the inspection report submitted by the assistant executive engineer, isn't it? Of where? But RO South Bank? This is by page 108 is whose?
South Bank, regional of the South Bank.
Huh? Resident of?
Regional.
Regional officer of your whereby an inspection report have been enclosed. Inspection report dated 10/4/2024 have been enclosed. It is the opinion of this court that in terms with the Air Bracket Prevention and Control of Pollution bracket close Act 1981, there are two requisites. One is the consent to establish and the one is consent to operate. The petitioner have been granted the consent to establish, and it is on the basis of the consent to operate that the petitioner could run the said clean. There was no urgency. There was no such urgency that the bricklaying, that the petitioner would be starting its bricklaying, and as such, to waive the basic necessity of issuance of a show cause, which is also the mandate of Section 21 of the Act of 1981. There is also, it also appears that the said decision was taken on the basis of some inspection report. And the said inspection report was also not furnished to the petitioner before cancelling the said consent to establish by the impugned order. Today, when the matter has been taken up, Mr. S. Borwa, the learned counsel appearing on behalf of the respondent number 2, 3, and 4 submits that the state respondents are taking steps for reconsidering its decision, which is impugned in the instant proceedings. He submits that some time may be granted in that regard. Taking into account the above, this court is not passing any orders, thereby by disposing of the writ petition. An update in that regard be placed by Mr. S. Borua, the learned standing counsel of the Pollution Control Board, on the next date. List the matter again on when? 13th of August, 1 month, 13th of August 2026.
I leave it to your lordship, but I'm still on my, because I want that, my lord, by following proper procedure, rightful owner have to be granted that.
Why did you enter into an agreement for sale?
Now, that agreement in the sale, your lordship kindly see. Entering very interestingly, I am replying my miscase, I have retained everything, my lord. Because 2022, the amount has been released, some amount has been released.
That amount is,
After my lord,
no,
immediately when I came to know,
94 lakhs were released. 94 lakhs was released in 2022.
my lord,
Thereupon, there is further release which have happened.
no, my lord, thereafter, my lord, my lord, called me from, I was in Calcutta, I was called and they claimed a MOU. Then sign a power of attorney, but subsequently we revoke also. Subsequently we revoke. But before that, my lord, Oil India Authority have, my lord, they have done the illegal thing, now try to come, my lord, regularize for some of the other members, my lord. That's why I'm before this honorable court only because of the action, because your lordship.
Have you challenged the power of attorney?
No, that I have already revoked, my lord. Already revoked, my lord. That power of attorney, again I am submitting, my lord. Power of attorney, which was given to the afterward, my lord.
Understood. But the power of attorney gives him the right for the purpose of taking the compensation.
My lord. But it was.
Now, on the basis of whatever agreement you have along with the power of attorney is not before us.
My lord.
You may have the agreement as to how. So it is between a dispute between you and the power of attorney holder.
That, my lord, of course, it is not challenged, my lord, till now, but subsequently, but why I am filing this petition before this honorable court? So actually, my lord, we are challenging the action of the respondent authority, the motive of respondent number 1 and 2. Because, my lord, before going to requisition, my lord, certain procedure has to be followed. But that what they are doing, my lord, they say that from the power of attorney holder, they have the person who is at that point of time holding the, my lord, management of the, my lord, particular, they with him, my lord, sale did they have executed.
What
They
is
say
the
the court
interim
is-
order passed?
Yes, sir.
What is the interim order?
Whatever amount is left with us, there is a 50%.
Now
of
420 has been withdrawn.
Vikram Sharma case is no.
That is, my lord, I don't know, my lord. That is the case, my lord. Now they one by one, my lord.
So if the interim order, there is
But
an
that order,
interim
interim
order
order is
passed here,
continued
which
here
says
also.
the same interim order will also operate in the
In this
present
case
case.
also.
Now, with that interim order not there,
This into.
how can there be an interim order here? Because
No,
if-
that was the order passed by this honorable court.
Huh?
Although they withdrawn, my lord, afterward, my lord. When I filed this, my lord, this petition before this honorable court, at that point, it was not been withdrawn. It was not withdrawn then, time.
Understood,
After
but
filing-
now there is no
Now,
interim
today,
order.
That order has not been there.
There's no order.
There's no order.
So
No.
in this case has
That
to
order
follow
was
that
still
case.
continuing. That order was still continuing. There is a order
If
passed in
any
this case.
part of the assessed compensation amount has remained to be disbursed, then the shall not be disbursed till the returnable date.
3.5 CR is the amount. That
Have
is
you disbursed it?
not disbursed because of this order it is there with us.
We do one thing. Disburse the entire amount except keep one fraction of it for hypothecation.
There are now multiple disputes coming. Now he is also one entity who has also been there. These disputes.
What is maybe? No, I'm not on that. You see, the petitioner's claim is one person,
One share of that.
one share.
Yes.
So you calculate one share and keep that, and remaining you go ahead and do it because
We will not pay that unless the sale deed is not registered. We are stuck somewhere in between. Agreement to sale is there.
No,
We have paid the money, but now agreement sale deed is not happening.
have the petitioner got a single penny?
84 lakhs.
No, my lord, I have denied, my lord. I'm an affidavit, I have denied.
Where is your receipt?
I mean, detective.
Yes, page 121. These are all these. 10 lakhs, 10 lakhs, 10 lakhs, and 10 lakhs, 10 lakhs, and 4 lakhs. We have got this money.
No, my lord, that is, I have denied, my lord. In my affidavit, my lord, I have denied, my lord. In there, I have filed a reply, my lord, to this case, my lord.
No, to these affidavit in reply you have not filed. Are you denying that you have not
Yes, my
received
lord,
34
para
lakhs?
page 106, my lord. Of the IA.
106.
My lord.
Where?
Last, 106 last paragraph, my lord.
The deponent category having received any amount of remand or any amount towards her alleged compensation as falsely suggested by
The
so.
story regarding the,
Now, is this account yours? SBI and this account? This is at page 121.
account is award, it is not that amount, my lord, it is in different head, my lord, in different aspect.
What amount? This is the amount which
No,
he is saying.
suppose, my lord, your lordship kindly
No,
see.
my question is, this is the amount he's saying he has paid. And you are not saying to that, okay, if this is your account, then we'll hold you in contempt for making a false statement. Let us see. Yeah. We fix it on after that,
My
but
lord.
if we find it,
My,
that
let
this
me,
is
let
your
me go
account.
through it, my lord, because mean they are.
Now, if this is your account, then you are making a false statement.
No, my lord.
No, this, because this amount, no,
before that, your
no,
lordship-
Mr. Counsel, this amount was transferred on 27/3/2023.
My lord.
You have filed this reply. Have you mentioned that this amount you have received 34 lakhs, but this is nothing to do with this account?
This amount is not related to the compensation amount, my lord.
I'm only asking, you have said the deponent
No, so far, my lord,
categorically
my
decides,
information goes, my lord.
denies having received.
Let me clarify.
No,
on
no,
this,
kindly see page 106.
my lord.
The deponent categorically denies having received any amount of rupees so and so or any other amount towards her alleged share of compensation as
Yes.
suggested by the applicant. You are categorically saying this. He says that this is the amount which have been paid and it is gone to your bank account. Now you say you have this happened in 2023. Have you returned this amount to the person concerned, or you have to show us as to it?
Take instruction on that one.
Otherwise, we draw
No, you are
contempt against.
One aspect also.
We will initiate 340%. Don't make up false statement.
One aspect in this regard, on 14/3, we had paid 7 crores. And this transaction is of 27/3, the proximity. 14/3, the money was paid, and then the disbursement was made on 27/3. So the proximity will also indicate that this is the money coming out from the 7 crores that All India has paid.
So let me take instruction on that point, my lord.
I indicated that we draw 340 proceedings if it is so. Heard Mr. T.J. Mohanto, the learned senior counsel, assisted by so and so appearing on behalf of the petitioner. Mr. A. Sharma appears on behalf of the Oil India Limited. Mr. So and so appears on behalf of the respondent number. Respondent numbers 4 and 5. He appears for respondent number 3. 5, 6. So and so appears for respondent number 7 to 42. The present petition has been filed by the petitioner, seeking various directions upon the respondent number 2. To the effect that the respondent number should declare to the petitioner about any compensation which has been paid and to whom. With regard to the land acquired by the respondent number 1 for laying down the pipeline, the petitioner have also sought for a direction upon the respondent authorities to complete the payment of the entire compensation amount to the rightful owners of the petitioner, of rightful owners of the land in question. At this stage, it is very pertinent to take note of that the petitioner herein has approached this court by filing a writ petition as representing the Kotongpani Tea State. There is no authority being shown placed before this court that the petitioner can represents the Kotongpani Tea State. And moreover, the Kotongpani Tea State under no circumstances can be said to be a juristic person. Be that as it may, the petitioner herein is a shareholder. He is a owner of the land wherein the Kotongpani Tea State have been, Kotongpani have been is set up. It is a specific allegation at paragraph number 3 of the writ petition that an amount of rupees 94,70,670 have been disbursed as surface compensation to the respondent number 4 by the respondent number 1. By the respondent number 1. And the respondent number 4 have cheated the owners of the said owners in connivance with the respondent number 5, the then manager of the tea state. The petitioner have also the said statement makes it very clear that a dispute is between the petitioner and the respondent number 4 as regards non-payment of compensation. Non-payment of the surface compensation. It is also mentioned at paragraph number 11 of the writ petition that the total amount of rupees 10 crores 51 lakhs 83,000 being the part payment against the land value have already been disbursed by the respondent number 1. And other compensation amount that is land value with solatium of rupees 7 crores 1 lakh 22,000 and rehabilitation grant of patadas of rupees 3 crores 50 lakh 61,000 still remains to be paid.
Figures are otherwise not correct. These figures are otherwise not correct. It is what has been stated.
And that is his statement.
It's clarified now.
Here also it is very relevant to take note of that it is the very admission on the part of the petitioner that the said amount of rupees 10 crores 51 lakhs 83,000 have been paid to the respondent number 4. On the other hand, the respondent number 4 categorically mentions that the petitioner have been paid an amount of rupees 34 lakhs 16,668 on 27/3/2023 itself by bank transfer, which is evident from Annexure 14 at page 120 of the interlocutory application filed by the respondent number 4. This code also, on the other hand, takes note of paragraph number 12 of the affidavit in opposition, a written objection filed by the petitioner. Wherein, if there is a categorical denial that a petitioner have received any amount of rupees 34,16,668 or any other amount towards her alleged share of compensation. This could have also heard the learned counsel, Mr. A. Sharma, the learned counsel appearing on behalf of the respondent number 1 and 2, who submitted where's your affidavit? Your affidavit?
Affidavit is filed on 13/5/2026.
Wherein you submitted. That there is a dispute between the petitioner as well as the various shareholders, various co-owners of the land. And this dispute is sought to be raised by way of a writ petition by unnecessarily involving the respondent number 1 and 2. The learned counsel submitted the respondent number 1 and 2 had entered into an agreement for sale for purchase of 39 bighas, 4 katha, 11 lechas of land from the 37 persons who are the legal heirs of the original 5 patadas, namely late J.N. Sharma, late S.N. Sharma, late B.N. Sharma, late H.N. Sharma, and late M.N. Sharma.
It was the HUF. It was the HUF.
The learned counsel further submitted that once Sri Babul Sonwal was appointed as the attorney or the authorized representative of the various landowners, including the petitioner, and in that regard, referred to paragraph number 23 of his affidavit in opposition. And specifically referred to deed number, registered deed number 618, executed by the petitioner in favor of the said Babul Sonwal.
Out of authority is a paid 200.
The learned counsel further submitted that as per its policy, as per the policy of the respondent number 1, after releasing of the surface compensation, another 50% of the land compensation amounting to rupees 3,50,61,000 is to be released pending execution of the registered deed of conveyance.
Yeah, just state the payments that we have paid.
Where is it?
Page 117 is the second payment.
How much? Why haven't you mentioned in your affidavit?
I have mentioned.
Where?
Page 117 is that declaration, where Lordship will find the DD. The reference to the demand draft.
Now, Mr. A. Sharma, the learned counsel appearing on behalf of the respondent number 1 and 2 submitted that apart from the payment of the surface compensation, an amount of rupees 7 crores 2 lakhs 84,000 have been paid to the respondent number 4 towards payment of rehabilitation grant for an area at measuring 40 vigas.
And thereafter, this amount, 50% of the agreed.
Further to
Sale.
that, the respondent number 1 and 2, 1 have also arranged release of 50% of the land compensation amounting to rupees 3 crores 50,000, 50 lakhs 61,000
White demand draft.
pending execution of the registered deeds of the conveyance and release the said amount in favor of the power of attorney holder upon execution of the registered agreement for sale dated 10/4/2024. The learned counsel for the respondent number 1 and 2 further drew the attention of this court to the registered agreement for sale dated 10/4/2024, which will also show that the petitioner entered into the said registered agreement for sale through her power of attorney. From the above analysis, it is therefore appears that the instant proceedings is primarily a dispute between the petitioner as well as the co-owners of the lands in question, including the respondent number 4. It is also seen that the respondent number 4 have categorically stated that an amount of rupees 34 lakhs 16,668 have been transferred to the petitioner's bank account bearing account number what is the account number in the area? No.
Page 120, madam.
No, this is not an account number. This is not the account number. This is the UTR view.
Now you will see the middle column. NEFT number will be transferred to their number.
To the bank, no, bank account number. 3199T01044T03.
Name is also referring. Her name is also referring there, Priyanka.
So, okay. However, these aspects have been denied by the petitioner. Consequently, this court fixes this matter again on 21st of July 2026. The petitioner is directed to file an affidavit before this court as to whether, stating entirely as to whether the account of the petitioner mentioned herein above, being account number so and so, number to na, page 121 of the style belongs to the petitioner or not. And further, whether the petitioner, after receipt of the said amount from the which have been transferred through which was been transferred by the respondent number 4, have taken steps for returning of the said amount. What is that IA for?
State is like the holding of the money by Oil India.
You want to pay?
I don't want to pay, but sale deed is yet to happen.
The 3,50,000 crores you have paid.
50% I have already paid when the agreement to sale happened. The rest 50% I will pay when the sale deed is executed.
Oh.
But there is no sale deed happening because of dispute now.
Good stuff.
As it is, I will not.
This court have also heard as regards the impact of the interim order. It has been submitted by Mr. A. Sharma, the learned counsel appearing on behalf of the respondent number 1 and 2, that the remaining consideration would be only paid at the time of execution and registration of the deed of sale. Consequently, the instant application which has been filed for vacating of the order, and consequently, the instant or application so filed for vacating of the accompanying application being ISO 102/2026 filed for vacating of the interim order has no relevance. Is not relevant. Is of no relevance. Besides, the interim order which was passed by this court on 1/8/2025 was linked with the order which was passed in deputation number 420/2025. The said petition having been withdrawn, the said interim order also do not survive. Under such circumstances, it is therefore the opinion of this court that there is no interim order in the instant proceedings. Eyes closed.
Lordship had raised the query earlier that how are we affected as petitioners? Lordship, in the petition, especially in paragraph number 3, it has been indicated that we are registered pharmacists in the state, Your Lordship.
No. How are you concerned with these? Are you a member of these? Because amongst the member only
Lordship.
these people can be
Lordship.
appointed. They are not before us.
Lordship, the problem is, Lordship, the meeting was called for on a certain date by a party who was not supposed to be elected. The registrar has to be somebody who holds a B Farm degree or a M Farm degree.
Understood,
Lordship.
everything understood. But the fact that you cannot be a participant in the meeting also.
Lordship, I can be, but there is a
How?
stipulated time. There's
How
a
can
time
you
frame.
be a participant of that meeting?
I'm sorry. My lord, in this case, the petitioners, my lord, participated in the process. Now, before that, if your lordship would kindly come to, first of all, my lord, this registrar who has set in motion the election process, he is not even competent, he is not eligible to be appointed. Therefore, my lord, entire thing vitiates. If your lordship would kindly come to page number 28, my lord.
Yeah.
2A. In supersession of earlier government notification dated 7/2/24, and in the interest of public service, Sri Himangshu Pratim Nath is hereby removed from the register of Assam Farming Council with immediate effect. Further, Pranoti Gogoi ACA Joint Secretary to the Government of Assam, Health and Family Welfare Department is hereby designated as in charge register of Assam Pharmacy Council with immediate effect until a new registrar is appointed. My lord, if your lordship would now kindly come to page number 38. Who can become a registrar? First, Milord will kindly come to page 37. This is by Pharmacy Council of India. Subject required qualification of Registrar of State Pharmacy Council. With reference to the subject cited above, I am directed to inform that Council in its meeting held on October 1996 has decided that Registrar of the State Pharmacy Council should be a registered pharmacist and should possess D Pharma as a minimum qualification. Then Milord will kindly come to page number 38. This is another office memorandum issued on 7/11/25 by the Pharmacy Council of India. This is in continuation of the Council circular dated 9/9/97. It has been observed that some of the state pharmacy councils are appointing registrar without any pharmacy qualification and is violating Chapter 3 of the Pharmacy Act 1948. All state pharmacy councils are directed to appoint registrar who should be registered pharmacist with a valid pharmacist registration. However, the qualification of the registered pharmacist in order to of preference shall be as under. First preference, Bachelor of B Pharma for an institution approved under Section 12 of the Pharmacy Act. Second preference, Diploma of Pharmacy from an institute approved under so and so. So, my lord, in order to become, my lord, a registrar of a state pharmacy
Mr.
council.
Chaudhary, I understand that. My question is here.
Yes.
You are calling in question the first meeting, which was called by the registrar in charge. Okay. Can you be a participant of that meeting? My question is that.
No, my lord. Actually, my lord, what had happened? The entire election has been challenged in another. There are two other writ petitions pending on this point. My lord. In one of the writ petition, we have assailed the election. Because our case is, my lord, this registrar in charge is not competent to set in motion the election process because he's not a registrar who is qualified. It goes to there are two other writ petitions pending. In one of the writ petitions, I appear, recently I've been engaged, and in another petition, I think my friend Parshad Nair appears. Number 2, 6936 of 2026. Abeta? 25, Abeta? My lord, along with this, my lord, another writ petition is tagged. If your lordship have all these matters together, my
Whether there
lord,
is a stay to the election? No. So then in that case, how can there be a stay to this?
election is stay assembled. Well, actually, to be honest, this matter I have been engaged only recently, my lord. I have yet to go through it. But here we have challenged the, my lord.
Understood,
But
but
my lord,
you-
we are a stakeholder, my
No,
lord.
you cannot be a member of this committee unless that election is not set
No, my
aside.
lord. We have been defeated.
Understood.
Ah.
So you cannot be a member of this committee.
No, my lord. We'll kindly have a look at paragraph, my lord. 7 and 8, my lord. Sorry. Paragraph 9. Page number 13, my lord.
Yes.
Now, first part we have dealt with that the respondent number 4 is not competent. Then if your lordship would kindly come to page 14, last two sentences, my lord. In the instant case, has your lordship got it, my lord? Page 14, last two sentence.
Okay.
In the instant case, it is an admitted fact that respondent number 4 does not possess the aforesaid degree or diploma. Further, respondent number 4 is not a registered pharmacist under the Pharmacy Act as such. The notification dated 8/9/25, whereby respondent number 4 was appointed as in charge registrar of the Pharmacy Council is honest in the eye of law. Therefore, in the humble submission of the petitioner, any action taken by the said respondent number 4 subsequent to her appointment as in charge registrar is per se illegal and in violation of the provisions of the Pharmacy Act and rules framed thereunder, and hence liable to be interfered with. Then, my lord, will kindly come to paragraph 10, my lord. Petitioner begs to state that Section 26 of the Pharmacy Act empowers Assam Pharmacy Council to appoint a registrar of Assam Pharmacy Council with previous sanction of the state government. Provision of the Pharmacy Act do not provide for any provision of appointment of an in-charge registrar, that too without possessing the required qualification laid down in the statute. Communication dated and OM asserts the impugn action of respondent number 1 in appointing so and so is bad. So, my lord, our case is, my lord, since respondent number 4 is not competent to hold the office of registrar, how can he, my lord, organize the election? Therefore, the entire thing is bad in law.
Where is the requirement for holding the, that the registrar has to call for it?
My lord, I have shown regarding that election, my lord.
Mm.
Yes.
Now, how does the Pharmacy Council of India has the jurisdiction?
It is there in the rules, my lord. We have annexed it in our affidavit. Rule number 40.
Act is also there.
Act, I don't think.
No, it's
anything
in the
is-
rule.
Where?
Lordship will find it that it starts at page 69 of our affidavit proposal.
Yes.
Page 69.
Ah.
And relevant part, Lordship will find at page 75. Rule number 14 down below.
As soon as may be possible after completion of the election under clause A and C of section 19, and after appointment under clause so and so of that section have been made and notified in the Assam Gazette by the state, the registrar shall convene a meeting of the members of the council for the purpose of electing a president and vice president of the council.
No, that I understand, the registrar can do it. My question is, how does the Pharmacy Council have the power to state it? This
Because
notice
we are-
memorandum, there
We
has
are
to be some.
we are registered pharmacists, my lord, and we are the electors. For example, my lord, an election petition can be filed by an elector as well as by a candidate.
Now, whether does the Pharmacy Act state about anything?
Yes, my lord. Section 19. Section 19, my lord. Constitution and composition of the state council. Except where a joint state council is constituted in accordance with an agreement made under section 20, the state government shall constitute a state council consisting of the following members, namely 6 members elected from among themselves by registered pharmacists of the state. 5 members of whom at least 3 shall be person possessing prescribed degree or diploma in pharmacy or pharmaceutical chemistry or registered pharmacist nominated by the state government. 1 member elected from among themselves by member of each medical council or council of medical registration of the state, as the case may be. The chief administrative medical officer of the state, ex officio, or if he is unable to attend any meeting, person authorized by him in doing so. Officer in charge of Drugs Control Organization of the state under the Drugs Cosmetics Act, ex officio, or if he is unable to attend the meeting, a person authorized by him. Government analyst under the Drugs and Cosmetics Act, ex officio, or so and so.
Now, if we see, Mr. Mr. Chaudhary, kindly see 46.
Section,
Ah,
yes. Power to make rules.
the
State government by notification in the official gazette make rules to carry out the purposes.
So it is
in-
the state government who can do it.
Power
My-
is,
Now,
power is
if you see their rules, which is the 1959 rules,
page 69.
page 70 onwards,
Yeah,
it says the register. Kindly see the definition of register 1D.
register means the register of pharmacists prepared under the provisions of the.
Selection under clause A of B1 or under so and so the register of the registration tribunal appointed under 1 of section 39(1). Now, if we go by this, now kindly come to 11. Election of members.
Rule 11.
Rule 11. Election of casual vacancies. Now, this is after declaration of results. 9.
For election of member under clause C of rule 19, registrar shall at least 2 months before the date. So, my lord, the registrar's role is pivotal, my lord. To be honest, my lord, actually this matter came up for you, my lord. Actually, my lord, there was a note by the Lawajima court, that is why I didn't come prepared also.
Now, my question is only
Yes.
one thing. How does the Pharmacy Council of India derive the jurisdiction in view of 46? My question is that.
Section 46.
Because the power is given to the state to make the rules. Register aspect is not there in the act. Register aspect is there only in the rules.
The rules are framed to carry out the purposes of the act.
Act.
And the rules are not under challenge.
No,
And as per Rule 14, it is the registrar.
register. So, no, my question is, where does the Pharmacy Council of India come into the picture?
No, yes,
You-
sir, certainly,
your
my lord.
your basic case is
That's a Pharmacy Council of India's rule will come for the simple reason. The seventh schedule. My lord, when the Pharmacy Council of India makes a rule, my lord, the State Council is bound to follow it. They
no,
can-
this is an executive instruction by the it's an office memorandum, whereas the power is specifically given under 46 to the state.
When my lord, and the state government or an authority has power to make law under Article 73, pharmacy, a government of India can also issue, executive instruction, as long as on that field there is a power given under one of the in list 1 or list 3. So there is no difficulty on that, my lord.
No, my question is therefore, the
No, I
Pharmacy
have
Council
what-
of
I
India
have what
is
your lordships want to
Pharmacy
say.
Council of India is chapter 2.
Yes,
State Pharmacy Council is chapter 3. Okay. Now the power to make the rules is given not to the central government for that.
yes.
It is given to the state government for chapter 3.
No, my lord,
And chapter 3 says about the register. The act doesn't say about the register. My question is there. How does the Pharmacy Council, which is of chapter 2,
my lord,
can override?
I'll address your lordships on all these points, my lord. I've taken note of it because it came for orders. I don't think I thought, my lord, it was only for some note issued by the my lord Lawajima court.
Hmm.
That's why I didn't come prepared. Anyway, my lord, I'll address your lordships on this point. Meanwhile, lordships are also called for the other case on the same point where the election is under challenge 6936 of 25.
An election is challenged only on this point.
No, there's no other point regarding the ballots and all, regarding one of the voters.
My lord, what had
No,
happened?
and elections, can it be challenged by way of a repetition?
No, they put an appeal, my lord, appeal has been rejected, and that speaking order is under challenge in one court.
And my lord, they say all the records have been burned.
No, their allegation was that some ballots were burned. That it was allegedly there to now, here is the situation, my lord. The rule or the section 46, 26 says that, my lord, of the act, my lord, it says that, my lord, the registrar will have to be appointed by the council. The council is defunct from 2023. Now, my lord, the rule 14 says, my lord, for election of, my lord, vice president and president and vice president, it will have to be convened by the registrar. Now, without there being a registrar, the vice president and president cannot be appointed. Without there being a council, the registrar cannot be appointed. So that is the situation in the present case. The rule is silent on that situation as well as the act. From 2023, there is no state council. So there is no registrar.
No, he will be a different register. That is what I could find. That is why you find this
Yes.
in that office memorandum, an interesting office memorandum to the effect. I need see this.
That is why the insurance was appointed by the government.
Somewhere I found it just now that the register would be a returning officer register. Somewhere I found it.
They
No?
will be there in the rules.
Yeah.
My lord, according to section 26, State Council may with the previous sanction of the state government appoint a registrar, who shall act as the secretary and if so decided by the State Council, treasurer of the State Council.
But somewhere I just found out that the register will be a different register, the returning officer register or somewhere I found out this. Yeah. The meaning of the register means the register of the Assam Pharmacy Council. He is appointed under 26, okay? And in case of the first election under so and so, first election,
law.
we have to construe it in there because there is no pharmacy council.
Yes.
Clause A of section 19 or so and so, the register of the registration tribunal appointed under subsection 1 of section 30. So the person who is appointed from the registration tribunal will become the registrar for the purpose of this. This is what is the
Prima
definition.
facie, my lord, subject to further, my lord.
Maybe, Mr. Chaudhary, you may have a case on this that anybody else could not, because in rule 1D categorically mentioned that if there is no register available, because there is no state council available, then it will be the register of the registration tribunal, which is appointed under 31, who will become the registrar. Because the pharmacy, this register has to be appointed by the state council.
My lord, when my understanding subject to correction, my lord, first register means after enforcing the act, when the first time appointed, it is referring to that register.
No, understood. But as of now, there is no pharmacy council.
That doesn't mean, my lord, first register we can refer to now who is going to be appointed. First register means, my lord, after enforcing the act, when a register is appointed, is referring to that register.
No,
Subsequently, in accordance with the provisions of the act and the rules, the register has to be appointed.
no, understood. But my question, my problem out here is, it is the state pharmacy council will appoint it.
Yes, with the sanction of the state government.
Understood.
Yes, section
If we
26, my
see,
lord.
26A, the state council may, with the previous sanction of the state government,
Yes.
appoint a register who shall be here. Now the state council has not come into being. When there is no state council, what to do?
Was there. It was only till my lord 2023 it is not there. Whereas it was earlier, it was there. Actually, my lord, who has resorted to this advocacy? It is the state government, my lord. They have created the mess. I understand the person who was holding the charge all throughout. He is a drug inspector. He is a drug inspector. My lord, end of the day, the impasse which has been created, it is by virtue of the, my lord, condition or commission of the state government only, my lord.
Then tell me, who can call for a meeting? Election?
Registrar.
Now register is not there.
So first registrar has to be appointed.
How can a register be appointed unless the state
First-
council is not
First
there?
state council will have to be constituted.
How? Without the register? Problem lies there, na?
No, could be. There could be some answer somewhere, my lord. Let us
No,
find
no,
out.
the answer appears to be only by 1D.
Anyway, my lord,
Therefore, it says that when there is nobody out there, you have to bring in the register because there is always a person who is already there as a register. Maybe this in charge is wrong because there will be 100% registration of pharmacists. For that, a register will be there appointed. So that register will become that for the purpose of this.
Again, whether there is a tribunal or not, that this definition. Says, there will have to be a tribunal.
No, there has to be no.
Registration
No, here you see, preparation of maintenance, as soon as after this chapter has taken effect, the state government shall cause to be prepared in the manner hereinafter, a register of pharmacists for the state, which will be as per 32, 33 and 32 AB. The state council shall, as soon as after it's constituted, assume the duty of maintaining the register and so and so. The registers and so, and then 31 is the state. For the purpose of preparing the first register. Now, this is the first register. The state government shall, by notification in the official gazette, constitution a registration tribunal consisting of 3 persons and shall also appoint a register. So the registration tribunal will be separate from the state pharmacy council.
That register will be different.
Different. So therefore, it says that this register shall become the register till the state pharmacy council is not constituted. So, Mr. Chaudhary may have a good case as regards you cannot have that in charge businesses out there. You have to get hold of that person. Because there, for the purpose of AI, now, as of now, otherwise it becomes an unworkable situation. Mr. Chaudhary, this
Correct,
is an
correct.
inspect
No,
which
correct,
need
correct.
to. It is something like the egg and the chicken, I suppose. Huh?
Anyway, Lordship will fix a date after the vacation, my lord. We'll address your Lordship on all the issues.
In that case, the states will have to be completed.
My lord, this item I am told is fixed on 24/7. 6936. We can have it on that day.
Who is the
69
responsible? Who have you not
Here
been
I'll
able
appear
to
in this
serve?
case, no?
Whom
6936.
have you not been able to serve? 14 and 15. 14 and 15. Are these members of the Pharmacy Council now?
Yes,
Mr.
they are the new elected one.
Understood. So you are appearing for the Assam State Pharmacy Council? That is the elected body, isn't it? So you will get it served. We'll give you
Have
extra
two copies.
copies.
14, 15.
This court have duly
Yes.
taken note of the the order of the Lozima Court dated 5/6/2026, wherein it is seen that the service upon the respondent number 14 and 15 is not complete. This court also takes note of that Mr. B. Gogoi, the learned additional advocate general, appears on behalf of the respondent numbers 1 to 4, which includes the registrar in charge of the Assam Pharmacy Council. The respondent number 14 and 15 are members who have been appointed to the Assam Pharmacy Council. Under such circumstances, the counsel for the petitioner is directed to serve 2 extra copies of the petition to Mr. B. Gogoi by tomorrow, so that service can be effected upon the respondent number 14 and 15 through the respondent number 4. List this matter on 24/7/2026, along with WPC number
69236 of 2025. The interim order has to continue till then.
Mr. Chaudhary, I will not say anything. Against me. Nothing is going to happen. You also know nothing is going to happen. There is something. We'll see on next date. We'll take it up. Okay. Any decision so taken by the newly elected members of the by the Assam's Pharmacy Council, so constituted, pursuant, and any decision so taken by the newly elected members pursuant to the order dated 4/2/2025, 4/2/25, shall be subject to the outcome of the petition.
11.
What is this? You can say, one appears on behalf of the petitioner on call. What is the matter about?
Insurance claim.
Huh?
Insurance claim, non-payment of insurance.
Why you are not paying?
Because the suppression of the material facts and for that the hospital has been also made a party.
Have you filed your affidavits? Taking a complete list, the matter for final disposal on 17th of September 2020. 17th of September. Hey, nuksun ikon ako ni pala na po. Kaya na po.
May I please, Lordship? Lordship, let us list to the non-payment of compensation of acquisition of land, Lordship. So, Lordship, kindly see the last order dated 18/3/2026, Lordship. Para number 3, 6, and 7, Lordship.
Yes, what is your instruction? Now, another thing, I have a problem with this type of, because you see, you have to, if the land has been taken from them and you have constructed the road, the land has to be acquired by you. You can't just make the payment of compensation because how will you get the ownership of the land? The land has to vest upon the state tomorrow. Why you have not taken that steps? Have you made an inquiry as regards this? Mr. J. Hendrik, who appears on behalf of the respondent numbers 1, 2, and 3, submits that he has no instructions pursuant to the order dated 18/3/2026. It is relevant to take note of that by the order dated 18/3/2026, there was a specific direction upon the respondents to ascertain as to whether the lands of the petitioners have been encroached upon while construction of the road, while constructing the road in question. This court fixes this matter on 10th of August 2026, on which date the respondents number the respondent number 2 and 3 are directed to place a report by way of an affidavit as to whether the lands belonging to the petitioner have been encroached while constructing the road. Further consequential directions shall be passed upon receipt of such affidavit. It is observed that the said affidavit has to be filed on or before 3rd of August 2026 without fail. Hello.
Milord, we have challenged the award, Milord.
Mr. Chaudhary, I think we'll have it after vacation. Because this I have to pass the judgment.
Yes.
Anyways, there was no compromise, so obviously
No,
we'll
yes,
take it.
compromise failed. But not in July, Milord, August.
List this matter for final disposal on 11th of August
Yes.
2026. It's liberty given to both the parties to mention the matter for upgrading.
My lord, in this case, we are for respondent number 7, Milord.
At last, Mr. Chaudhary on this side during the day.
No, for government, private, private response.
No. Throughout the day, I think you are having most of the matters today in my court.
Lord, here we are filing the affidavit. Well, we have filed a SAR rejoinder. But they have refused to accept.
Lordship, on the last occasion when the matter was listed before Honorable Justice Manish Chaudhary, sir, my Lordship observed that before filing of an reply to affidavit in reply, they'll need the leave of the court in order to file. So without the leave of the court, they were denied to file the affidavit. And they had made the service today at 12 o'clock.
You have filed the reply?
These are SAR rejoinder. Rejoinder to
Where is that order passed?
It was not on the last occasion, 11/5/26.
11/5/2000? Where?
Although it is not reflected in the order, Lordship,
Don't
it was
make this
observed
book.
in the court.
Okay.
Also-
Mr. K. Chaudhary, the learned senior counsel, assisted by so and so, appearing on behalf of
respondent number 7.
respondent number 7. Submitted that today a SAR rejoinder has been filed. taking into account that the state law, rejoinder has been filed only today for this matter on 14th of August 2026. In the meantime, liberty given to the petitioner to file any reply therein.
Lordship, pendency of the writ petition should not be the barred in the Bakijai proceeding.
Haven't I passed that order earlier?
Lordship, if it is not passed in the subsequent orders, the Bakijai proceeding, they don't follow it, the Bakijai officer. They need explicit direction in all the court orders.
Why?
That is how, that is what they have been told us, Lordship.
What is this? They are saying anything?
We have placed a Lordship's order, but despite that, they are saying that.
I passed a long order in this matter.
Yes, yes, Lordship.
Pendency of the instant as well as the Bakija shall not impede in the progress of the I've asked you to go to RERA. You have gone there?
We had filed out there.
We are concerned and to understand that we observe the pendency cannot be construed the proceeding. Cannot be construed the proceeding which will be paid to impede the subdivision. The learned counsel appearing on behalf of the petitioner submits that this court should pass an order that the pendency of the instant writ petition should not bar the Bakijai proceeding. It is relevant to take note of that by an order dated 17/2/2026, this court had made it clear that the present batch of writ petition, the pendency of the present batch of writ petition cannot be construed as a proceeding which should affect or impede the certificate officer from proceeding with the Bakijai proceedings. Under such circumstances, in view of the said order being there, this court does not find it necessary for again retreating the same.
Lordship, in item number 16, the company has appeared fire. Yes. That is me infrastructure.
Whatever you know.
By this petition, Lordship, we have challenged the impugn eviction notice, Lordship. Whatever, Lordship, the petitioner, a land measuring 7 bigha, Lordship, 7 bigha and 9 lesaka, Lordship, was reserved for a Muchi Kopostan, Lordship. And the Muchi Kopostan is situated near Ulubari, Lordship. And the petitioner before your Lordship are the legal heirs of Mohant and Chokidar of that Kopostan, Lordship. The respondent number 6, Lordship, who claimed to be a Lordship, the president of a particular society, Lordship, has filed a representation before the Deputy Commissioner, Lordship, and claiming that some person encroaches the land reserved for the Muchi Kopostan, Lordship. And the Deputy Commissioner, Lordship, has not disposed of the representation. Thereafter, the state, Lordship, the respondent number 6, preferred a writ petition before the Honorable Court, Lordship. And this Honorable Court directed the Lordship Circle Officer at DC to make a verification and to initiate a proceeding for encroachment if any encroachment is there, Lordship. And thereafter, Lordship, impugn notice has been issued, Lordship. But the respondent number 6, Lordship, the main intention is to evict the petitioner, Lordship, and to settle other person of their choice, Lordship. And they have already made agreement with several person for in exchange of money, Lordship. And the petitioner, Lordship, being highly aggrieved, Lordship, against the illegal activities of the petitioner, Lordship, challenge their authority, the state committee, Lordship, and file a titleship before the civil just Kamrup, Lordship, Metro, And in the said title suit, Lordship, it was proceed ex parte against them. In the title suit, it was paid that Lordship, their declaration that the said society is illegal, Lordship has no legal.
No, tell me one thing. Once the matter was listed before this court on 6-3, this court said that let it be listed before Justice Soumitra Sekia.
Yes, sir.
What happened there?
Thereafter, Lordship,
It went to another court.
yes, sir, thereafter another order was passed to list the matter before.
We were any other court.
Yes.
Now what do you want?
Lordship, I have
Affidavit
filed
in
a.
reply has been filed.
Yes, yesterday I have filed the reply, Lordship, annexing all Lordship tenancy agreement, Lordship, other memorandum of Lordship, agreement, which was
Mr.
executed.
Chaudhary, you are appearing for whom?
4, 5 and 6, my lord.
What is that?
Petitioners in the other writ petition. Actually, my lord, we filed a writ petition. There was an order passed in the writ petition whereby Deputy Commissioner was directed to look into the matter. Now, my lord, now the present writ petition has been filed on the premise that circle officer has no jurisdiction to deal with the matter. Actually, my lord, they attended the hearing which were filed in the affidavit, my lord, and they have suppressed all these facts. Because Lordship will kindly take our affidavit, my lord. Page number, Lord, 102.
I remember taking another matter. Where's the other petition here? No.
Dispose of that. In fact, your Lordship directed the Deputy Commissioner to look into the matter.
Not yet at all.
Anybody
The
has
said
the order?
petition was filed by the DC of the respondent number 4, 5 and 6.
Ah. No,
For that,
DC of the said.
what is the order part?
Lordship 148. I have it.
Of
reply,
148.
Reply 148. Starts from page 150.
That resolution is found to be.
Because in the said
Insofar as the
petition,
second
they have
place
prayed for.
concerned, this court is of the clear view that an order has been passed by court where earlier in a resolution, and where cannot be challenged subsequently in another. In the representation stated 2 and 4 by number 3 and another one. Now this is by, who is this? Asraful Alam?
He is a leasee of under respondent number 5, 6 and 7. They lease out the reserve land to him, Lordship. To say Asraful Alam, Lordship.
So his writ petition has been dismissed.
Yes, Lordship. Because in the said petition, Lordship, he prayed for modification of order passed in the earlier petition. Because in the earlier petition, the petitioner, neither the petitioner, neither the said Asraful was made party to the said petitioner in pursuance to which the impugn order was passed.
And what has happened? Some suit is filed.
Yes, suit is filed
you?
challenging the, yes,
What?
and for declaration that the society represented by the respondent number 6 is illegal, has no authority on the land of the Musi Compostang. And said suit is proceeded.
You claim to be a Musi,
Yes, sir.
one of the persons for whom the land was initially settled at one point of time.
Yes. Reserved for Musi.
Now, what happened to this case? Tell me another case is there. What happened to the 1723 of the 2023 has been dismissed?
Yes, sir.
Huh?
5084 has been dismissed. And 10 Lordship,
1723, what has happened?
page 40 Lordship.
Page 35. Considering the dispute is reviewed, that since there is already a representation submitted, the same may be disposed of, and if any unauthorized occupants are found by the human after meeting the field verification, then the necessary steps be taken under so and so. Okay, on the basis of this, notice was issued to you,
Yes, sir.
isn't it?
Yes.
Now, you have filed your reply
Yes, sir.
before, in the proceedings? No eviction proceedings? Huh?
They appeared in the hearing. The official of the circle office, came to spot, and conduct a hearing.
Huh.
But it was just only a hearing.
Anyway, you appeared in there, out there.
Yes.
Then what happened?
Then Lordship, thereafter impugn notice has been issued.
No,
Because in our affidavit, we have given the proceedings itself. This comes to
then
page
this order is
101,
passed
my lord.
on 8/9/2024.
Yes.
And this order you have not challenged.
No. Because
And
we
in
have,
fact, he has suppressed this, my lord.
because
You are
we had no,
challenging, you are challenging
Lordship, because
12/9
The consequential order has been challenged.
Oh, no. They have challenged the eviction notices or 12/9.
Yes.
yes,
Have
After,
not challenged
after 8/9,
8/9/24 order.
after 8/9.
Yes.
because we had
Now you have not challenged the 8/9.
we had no knowledge at that time, because in the impugn notice, only the petition number was there. 148, 48 people.
Now, against it, this is an order by the DC. This is an order passed under Rule 18. Why you are not filing an appeal before the Board of Revenue?
Since Lordship, this eviction notice was issued, Lordship, at that time, the petitioner had no other alternative but to
It's okay.
approach this court, Lordship.
You now approach the Assam Board of Revenue better off. What do you think?
Give them some protection. Lordship.
Huh?
Give them
I
some-
protect you for 30 days. In the meantime, you file. 30 days, the interim order will continue. In the meantime, you file before the Assam Board of Revenue. Because this is an order which is appealable.
Because at that time.
Because you see, you have to, as of now, Mr. Counsel, you have not challenged the 8/9/2024 order. You have to challenge it here. You are challenging the notice, the consequential action. If you can challenge the consequential action, it is not going to help you out unless you don't challenge this,
The parent order.
the parent order. So you challenge this, I give you the liberty, go there. And if it is filed within 30 days, they would not insist on the question of limitation. And the interim order would continue till if you file within 30 days, interim order will be taken to, will continue till the date of consideration of the appeal by the Board of Revenue. Okay. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner.
Your Lordship, some more time, Lordship, the location is approaching.
What?
Some more time, 45 days.
Why?
10:30.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Petitioners, who's Mr. Vijay Talukdar, the learned senior counsel, Revenue PR Mohanto, Vijay Talukdar for respond number 2 and 3, assisted by Kumar. And Mr. K.N. Chaudhary, the learned senior counsel, assisted by so-and-so, appears on behalf of the respond number 4, 5, how many? 6, 7, 8. 6, 7, and 8. 6, 7. The petitioners herein have approached this court challenging the eviction notices which were issued on 12/9/2024. Thereby asking the petitioners to vacate the land in terms with Rule 18.3 of the settlement rules as framed under the Assam Land and Revenue Regulation 1886. it is relevant to take note of that the respondent number 4, 5, 6, and 7 had filed a writ petition being WPC number 1723/2023 before this court. The learned coordinate bench of this court by an order dated 10/6/2024 passed directions upon the Deputy Commissioner, Kamrup Metro, to carry out field verification and, if necessary, steps be taken under the Assam Land and Revenue Regulation 1886 and other ancillary provisions of law to ensure that the lands which were allotted by the government for the purpose of Muchi Koborstan are used for the same, and all required steps be taken to ensure that the purpose of the use of the land is not restricted by undue and unauthorized occupants. Paragraph 9 of the said order, dated 10/6/2024, being relevant, is reproduced hereunder. The records further reveal that in pursuance to the said order dated 10/6/2024, notices were issued to the petitioner on 7/8/2024. It is the case of the petitioner that thereupon eviction notices were issued on 12/9/2024, which has been assailed in the present proceedings. This court, by an order dated 27/9/2024, issued notice and further directed on 12/9/2000, eviction notices were issued. Subsequent thereto, this court, by an order dated 27/9/2024, issued notice and further directed that till 4/10/2024, no further coercive action should be taken against the petitioner on the basis of the eviction notices which were issued on 12/9/2024. Upon notices being issued, the respondent numbers 4 to 7 have appeared before this court and have filed their affidavit in opposition. From the affidavit in opposition, it is apparent that pursuant to the notice which was issued to the petitioners on 7/8/2024, the petitioners were granted an opportunity of hearing, and thereupon an order was passed on 8/9/2024, whereby the claim of the petitioners were rejected, and it is on the basis thereof the eviction notices were issued on 12/9/2024. It is, however, taken note of that the petitioners have not challenged the 8/9/2024 order passed by the District Commissioner, Kamrup Metropolitan District. It is a submission of the learned counsel appearing on behalf of the petitioner that the petitioner had no knowledge about the order dated 8/9/2024, and it is only on the basis of the affidavit which have been filed by the respondent numbers 4 to 7, the said order came to light. This court have also taken note of that the order which has been passed by the District Commissioner, Kamrup Metro, dated 8/9/2024, is an order which is appealable under section 147 bracket A of the Assam Land and Revenue Regulation 1886. But this court also takes note of that the aspect as to whether the petitioners have a right over the land in question are questions of facts which can be very well adjudicated by the forum, by the Assam Board of Revenue, on the basis of materials which are being placed before the Assam Board of Revenue. In addition to that, this court have also taken note of section 148 of the Assam Land and Revenue Regulation, which permits that an appeal can be filed within a period of 90 days. 90 days from the date of the order dated 8/9/2024. It is the opinion of this court that as the petitioner claims that they have come to learn about the order dated 8/9/2024 only upon the affidavit which have been filed by the respondent numbers 4 to 7 before this court. And further, the petitioner and further, this court is not inclined to entertain the instant with petition on the ground that the petitioner have an alternative and effective remedy available. The period, appropriate directions are required to be passed for the purpose of consideration of the appeal if filed by the petitioner within a specified time without insisting on the question of limitation. Accordingly, the instant with petition stands disposed of with the following observations and directions. This court is not inclined to entertain the instant dispute, taking into account that there is no challenge to the order dated 8/9/2024 passed by the District Commissioner, Kamrup Metro. Number 2. Liberty is granted to the petitioner to file an appeal against the order dated 8/9/2024 passed by the District Commissioner, Kamrup Metro, before the learned Assam Board of Revenue. It is observed that if the appeal is preferred within a period of 30 days from the date of the present order, the said appeal be considered taken up by the learned Assam Board of Revenue without insisting on the question of limitation. This court also takes note of that if certain interim protection is not being granted to the petitioner till the period within which the petitioner have been granted the liberty to prepare an appeal, the petitioner would be evicted, and thereby the filing of the very appeal would become infructuous. Considering the above, this court therefore directs that if the petitioners prefer the appeal within 30 days from the date of the present order, the interim order so passed in the instant proceedings shall continue till the consideration of the appeal by the learned Assam Board of Revenue. Yes, what is this?
Lordship, I 2022,
I for what?
for substitution of legal error of petitioner number 11. Who died on 13/3/2026.
I for?
Substitution of legal error of petitioner number 11.
Has this IA 1624 been dismissed or not?
That thereafter, Lordship, after substitution, Lordship,
This, I think we should dismiss. How can there be a stay to section 30? It's a statutory amendment. Whom do you want to substitute? Who died?
11, page 11 of the I 2022.
Huh?
Page 11, Lordship, legal error of the petitioner.
Petitioner are 17. Which petitioner died?
Petitioner 11, Lordship.
Petitioner, the 11 died. He substituted in place of the petitioner, namely Akhtar Hussain. in the petition number one. Petitioner number 11 is hereby this Moni Hazarika, Sahnaz Hussain and Imran Hussain. Isn't it?
Yes, sir.
This is an application filed for substitution of the legal representative of the petitioner number 11 who expired on 18/3/2026. Was taking into account that the right to sue survived upon the legal representatives of the petitioner number 11. It is the opinion of this court that the legal representatives of the petitioner number 11 is required to be substituted. Accordingly, the legal representatives of the petitioner number 11, whose names appear at paragraph number 3 of the application, are substituted against the petitioner number 11 as petitioner number 11. And arrayed as petitioner number 11.1, 11.2, and 11.3 to the accompanying writ petition. The learned counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court, and the registry shall, within 7 days, register shall, on the basis of the present order as well as the said memo of parties, make necessary correction in the cause title of the writ petition and update the same in the CIS. I stands to score. Now let us see the Khai. What is this by? How can you ask for stay of a 3D notification?
Lordship, in this case,
How is it possible?
Lordship, in this
The
case,
land has been acquired.
not,
The moment the 3D notification
Yes.
comes, the 3D2 says, the moment that notification is given, the land vests upon the state. How is it possible?
till today, they have not paid compensation to the.
So, compensation is different aspect from the land of acquisition. Not pressing. Not-
Lordship, probably they will withdraw the case because of the there's.
Then why you are
Quantum of-
substituting people?
Because
Huh?
because this application is filed for substitution, that is why I'm not pressing. And I will have to file an application,
But anyways, this type of application cannot.
that is after reopening of the.
We close this. Withdraw,
Same
dismiss, which one?
Withdraw, maybe withdraw them because.
MD, the learned counsel appearing on behalf of the petitioner, submits the petitioner would not like to press the interlocutory application being 1624 of the instant interlocutory application, for which the application stands closed on withdrawal. Other things, affidavits have been filed, taking into account that the pleadings are complete, leaves the matter on 6th of September 2026.
Prior to that, because of, I will file it after reopening lordship.
Why?
Prior to, because
What are you going to file?
other petitioner, they wanted to withdraw the petition, that is why.
The moment you make a prayer that you want to withdraw, we'll immediately
Because I have to file an application on.
No, you mention it, we'll bring it
No,
on 7th of September 2026.
Okay.
Yeah.
Lordship, petition number 128 herein are the legal heirs of the late Jean Prasad Sharma. The late Jean Prasad Sharma was the original owner and pattadar of this plot of land measuring 3 bigger 11 larges covered by dark number 59 KP patta number
Yes,
8.
what is your instruction? Why haven't you filed your affidavit? The whole matter. Or for PhD department, forest, excise, 2025 is fresh like yesterday. Something to the effect.
Lordship, we have applied for the mutation of the entire power, but till date neither.
etc. I cannot answer my.
No, some land has been taken.
There is a Jal Jeevan project they say.
We have applied for
They
the
want
self
to-
permission.
They have paid for demolition of that project.
Understood. So you are mean. Jal Jeevan? Are you not the public health engineering?
Yes.
Jal Jeevan comes
Jal
under
Jeevan
you.
comes under.
Then, although Jal Jeevan mission director, are you not appearing for two?
No, no, mission director is different.
What? Who appeared for Jal Jeevan? He's also the chief engineer, public health engineering there.
Mission director is not a is not a chief engineer. You know,
So you are not appearing for mission
but
director.
I can bring. The chief engineer is given a charge of mission.
So you don't appear
I
for,
appear.
are you appearing or
I
not?
appear.
So let us set aside that confusion. When are you filing your affidavit? Somebody's land has been taken away. Next week,
Miles.
a final opportunity is granted to the PHE department as well as the Jal Jeevan mission to bring on record the stand by filing the affidavit. Inasmuch as it is the case of the petitioner that their lands have been taken for installing a plant under the Jal Jeevan mission without payment of any compensation. This matter on 17th of August 2026. The affidavit on behalf of the official respondents be brought on record by filing the affidavit on or before 15th of August 2026. What is it?
May I please the lordship? National Highway Authority acquired the land losses, but while acquired the land, some deducts have been left out for assessment losses. That's why we approached the court losses. We submitted repeatedly documents also losses, and but not been taken into consideration.
Who are you?
We are the lessee over which our houses are there also.
Then
But we have submitted documents also losses.
what is your name?
Here is the losses.
Like if there's no payment being made, why are you not going before the arbitrator? This is under the NHI. Then no, if these people are lessees, then
Lessees,
also,
lessees.
that's a different aspect. Then also they have some right. There's no right. No. But Mr. F.U. this is
Lessees.
not.
We submitted application with that competent authority.
Then where? Have they referred it to the arbitration?
No, that not been referred.
Where is your application?
My application is dated lawsuit. Last representation 13/5/2025.
District and competent authorities. So and so. Okay, you refer it to the arbitration.
Lawsuit.
Also. Mr. F.U. in both the cases.
Lawsuit.
Where is your application in the other?
Other next one is lawsuits
First one I have got it page 72.
72 and next
the
one
other
is
one?
lawsuits page 80.
Page?
Page 80.
The bigger one.
80.
The petitioners in both the writ petition, heard so and so told you. In both the writ petitions, claim that they are person interested
Loss.
in respect to the acquisition of lands carried out under the National Highways Act 1956. Inasmuch as the petitioners are tenants
Loss.
of the land. The grievance of the petitioner is no, then you have to go for it's a case of apportionment. You're not questioning the yeah. Then you have to go under 384. This is wrongly paid. You have to go under 384 before the district judge. The grievance of the petitioner herein is that the landowners have been paid the compensation, whereas the petitioners have not been paid the compensation. It is the further case of the petitioner that on 13/5/2025, in respect to the petitioners in WPC number 2845 of 2025, and on 23/5/2025, in the case of the writ petitioners in WPC number 3135 of 2025. Representations were duly submitted before the competent authority for land acquisition. The competent authority for land acquisition ought to have, on the basis of the said representation, referred the matter under section 3H(4) of the National Highway Act 1956 for determination before the district judge, where District Judge Silchar, who is the competent authority to decide on the question of entitlement and or the apportionment of the compensation. And it is because of the same having not been done, the petitioner has approached this court. Taking into account the grievances of the petitioners in both the writ petition, this court disposes of this direction, both the writ petitions with the direction upon the competent authority for land acquisition, Kachar. This is the same notification, na? Same notification. Who have been appointed in respect to the acquisition of land from kilometer 4.560 to kilometer 24.560. Pursuant to the notification dated number SO.428 bracket E dated 2/2/2024. To refer the dispute to the learned district judge, Silchar, at Kachar, so that the said dispute can be adjudicated by the learned district judge, Silchar at Kachar at Silchar, within the scope and ambit of section 3H(4) of the National Highways Act. The same shall be done forthwith and shall be done upon receipt of a certified copy of the present order by the competent authority. What will be the additional district commissioner? Na?
Additional district. For district commissioner.
Huh?
For district commission.
Now for
The district commissioner, where? Kachar. Co-district commissioner, the competent authority for land acquisition within 15 days from the date of service of the certified copy of the president. These petitions to us.
Obliged.
What is this?
My lord, in this case, my lord, the respondent number 789, they have filed a demarcation case, my lord. In this case, they have agreed to, an order was passed to first hand over our land, my lord. Land we are possessing 2 biga, 2 katha 10 lesser out of 3 biga, 2 katha 6 lesser. So order is there.
Why haven't you filed affidavit? You don't want to file affidavit? Madam, what is your case? Your file. Why? Okay, Miss so and so, the learned class. Senior counsel is listed by so and so, appearing on behalf of the private respondent. All 789 submits that they would like to file affidavit in opposition. Mr. Lekman released this matter on 19th of August 2026. In the meantime, the state respondents as well as the private respondents shall bring on record their stand by filing the affidavits on or before 15th of August 2026.
Record may be called for, my lord. It could record it name.
You will see on the next week.
And
What is this? Directing the respondents to consider the statutory statement.
Today we have filed our affidavit in opposition.
You have filed?
Don't matter today, it's not on record matter.
Okay, it has been submitted to the Finance Department of the State of Assam. Finance and Taxation Department of the State of Assam has filed the affidavit in opposition. The copy of which is however not available. And the registry shall bring on record the said affidavit in opposition. Counsel appearing on behalf of the petitioner, the petitioner is granted the liberty to bring on record their reply, if so advised. This matter on 21st of August 2020. The registry shall bring on record the affidavit.
Same matter, my lord, supplementary same, my lord, only the assessment here is different.
Same.
No, my-
Same case. Here also you have filed.
no, my lord, one affidavit will suffice this matter.
Huh?
But only, I think with respect to attend.
Same in one affidavit, with the same order. It's filed an affidavit in opposition, that order. These are different years. Assessment year is different. Yes.
May it please your lordships. I'll make my submissions to lordship. Lordship have substantially heard us. In respect to what is
If I have substantially heard, why did you file an affidavit
because we had to factually.
without taking the link?
Lordships are already, I'm sorry we could have, but lordships have already granted us on 14th May. The,
18 May is different. After hearing the matter on that day.
But this
when I
is-
was about past the judgment,
This
then now you are filing an affidavit.
this is responding to this is responding to the affidavit in opposition, nothing more.
What do you mean?
It is responding.
The fact that the matter was heard. We asked you to file the reply then. You never said that you are going to file it.
No, lordship will kindly, I'm sorry, we should have granted
Because
leave. I'm not,
the facts
I'm
which are
not
there,
joining issues on
look,
that.
You have brought in new documents, you have filed it today, is very obvious.
These are documents that fell from, because there was a assertion from them that post the partnership, nothing is continuing in the name
So
of the.
you are, these assertions you are trying to deny
Because that assertion itself was wrong.
or to make it, but don't you think that then they have to get an opportunity to get it?
Very well, I'm not disputing that lordship, but all I'm saying is that lordships had in the meantime, last time, on 14th of May, had said that they would file an affidavit by a particular date and gave us time to respond to their affidavit. Since they delayed it because of a medical reason, a medical emergency, so we could not have filed it at that point of time. So we now took this break advantage to respond to that. That's all.
When did they file the reply?
They filed it on last day, on the day it was heard. If lordship had recalled that lordship had to call for the counter affidavit on the last day.
You are filing a reply against their
affidavit, which lordship had already granted on 14th previous. So in any case, lordships, they would like to have a look, let them have a look, lordship, but these affidavit is only limited to what has fallen from lordship on the last occasion and from there. Nothing beyond that.
Now, these affidavits are to show what you said on that day, that in respect to subsequent contract, it is being done as a corporation.
Not only ONGC, even other departments we have announced. PHE also.
No, we are only concerned with ONGC.
No, because this partnership says we'll cover all businesses of proprietorship, not limited to ONGC. So even PHE we are doing as a proprietor. So that contention of them is negated by these documents, which are much post the partnership.
That is from page
These are of 2025.
25, and the partnership was 2020. And PHE is 2026, page 489.
What has happened to the fire?
Yes, the FIR, we have annexed it, but let us not go to the FIR as of now today. Why, what,
FIR is very relevant because of the fact that when you filed it, what is the allegation in the FIR?
no, this is not a very happily worded FIR. Let me concede before Lordships even goes through it. But my submission, primary submission is this for your Lordship's consideration. Let us not expand the scope of this writ petition at the behest of the respondents. We were, before your Lordships, only assailing the process followed by ONGC in the matter of changing the details with respect to my vendor code. Whether the process followed by them,
No, your
It's a-
vendor code remains the same.
the details connected to it, the bank statement, the GST and the PAN. Whether the process followed by them,
Here they are saying categorically that we did it at your instance.
that is where. Therefore, I'll make just three quick submissions and conclude my submission. First and foremost, Lordship will firstly appreciate that the email, assuming that email generated from my email ID, please see the documents annexed. All the documents are signed by me in my capacity as a partner. First thing, Lordships, if I may bring Lordships to those documents.
No, first let us see the FIR.
FIR is not happily
No,
worded.
because
Lordship.
that gives us idea as to actually you got the change done by yourself, because they have the specific allegation is you approached them for change. That is the main problem. I'm only author. If we can see it from the FIR to the effect that you did not approach, obviously this court will pass an order in your favor. My question is that now, because there you may come within the ambit of that, you say that okay, give me money by this. You have done the work, who is here to make the payment? Now, if you say to him that okay, if you pay me in this particular account, I'll be happy, then obviously it will be deemed that you have done it. That will then it doesn't require a novation then.
No, what
Because your basic case is on 62.
no,
It may come under 63.
no, 63 also cannot be.
Why? Because you are the promisee.
Lordship, what?
He's the promiser.
There is a process. No, that is what I'm trying to say. That is what I'm trying to emphasize. This is not a case of 62, 63 because nothing has been amended in the contract per se.
Not necessary. That is why I'm saying.
It is
Your case is that it has to, it is not a case unless there is a novation done under 62.
not a novation, maybe
No,
an
no.
amendment.
You therefore say that unless there is a novation or anything done to the contract, you could not have shifted the thing out there and paid it in some other account to that effect. That is your case.
No, my case is not that. My case is you could not have replaced the parties from a proprietor to a partnership.
That is a novation.
So therefore not the change
But
itself.
you say that there is no novation. Without the novation, you could not have done that.
And that is what the contract also says.
Understood.
And the contract follows a process to be done.
Understood. So why not in 63 then? Why was 62?
Let us see
Why not
63.
63?
Let us have 63. The Lordship can have it. May I read section?
Yes, really?
Promisee may dispense with or remit performance of promise. Every promisee may dispense or with or remit, wholly or part, the performance of the promisee made to him, or may extend this time for such performance, or may accept instead of it any satisfaction which he thinks fit. Now, what is it that has come from them as a promisee?
You say that you are going to do a.
Pardon, Lordships.
You say that you have been granted a contract.
Lordships.
In that contract, there are reciprocal promises. One promise is, your promise is that you are going to do the contract
Lordships.
work.
Lordships.
Their promise is that they will make the payment.
Lordships.
Now your promise is, and as per your promise, you have done your work.
Lordships.
Now he becomes the promiser as a reciprocal promiser to make the payment to you. Now, here, if you see the illustration out there, you may
Yes.
very well find
Yes.
that if a person concerned is to get 5,000 rupees, He receives 2,000, he's satisfied, matter over. Now, you see, the English law is on a different aspect, but in respect to the Indian law, there's no requirement. You can be unilaterally, you can do it. There's no requirement of an agreement. You can very well do it.
There would perhaps be a requirement of an
So
agreement.
therefore, main question is, what is the affair?
There could perhaps be a requirement of an agreement, an agreement. I may
No,
be wrong.
It is not required. That is the difference. If you
If-
see that, if you see the judgment, I think standard chartered
Standard
bank
Citibank,
versus any something.
Citibank versus Standard Chartered. I have it, Lord.
Yeah. In
2004 one
that
is
judgment, if you see more particularly paragraph number 50,
47 to 50.
where it differentiates between section 62 and 63.
Yes, Lordships.
So therefore, it may be. I'm not saying it is. Me. So therefore, the question is, what is your conduct? Did you give a waiver? That okay, if you make payment to me in this manner, I'll be satisfied.
Oh, Lordship, I may just point out, Lordship, will for a moment, since this question has fallen, would Lordships kindly have a look at section 90 of the BSA 2000, maybe of some relevance, regarding presumption as to electronic messages.
Regarding?
Presumption as to electronic messages. Would
Okay.
Lordship have a look at the section itself?
Then I think we need to send it to the civil court.
Not at all, Lordship, because that is why my
I'm not
plea-
going to look into that.
No, because Lordships is now presuming that I have sent it. There is no presumption in law.
Therefore, I'm saying that the FIR has to be, if you have filed an FIR on 19/8/2025, there'll be contents to the FIR. We will never send it.
Pardon, Lordships.
In the contents of the FIR, there will obviously be something mentioned to the effect that they have committed some mischief. You never sent it because that is their specific allegation to the effect that you came over, they have even asked you to sign an indemnity. You even gave that indemnity. A particular clause in the indemnity was also asked to be changed. You again went and changed it. All these are specific allegations, but
Lordship will kindly come 27/9/2024 letter, my first letter. I completely deny anything being sent with my knowledge or consent.
where's that? That is only why. Show me
Yes.
that document.
Kindly come to this document dated at page 197. And Lordships will kindly come to page 2 onwards.
You don't deny the agreement. You don't deny the partnership.
We do not deny the part.
You say there is a partnership.
Yes.
That is the problem. Why
these-
last time I
These
did
were,
not
these were not sent at my instance. That is what we are saying. These documents, I have no knowledge or no consent.
Now you are being paid as per this additional affidavit in reply where you are being filed. Is it in this old account?
Yes, that's all. Now nothing is being paid present.
No. In other contracts.
Yes. Everything is in the old account. In fact, we have given the payment intimation also. Kindly have a look at the payment intimation. Kindly have a look at the payment intimation. This is of 2024. And see the vendor code and the bank account details.
Where paid?
Page 467. Page 467, Lordships.
This is dated
This would be
This is
lordships
24.
24.
No, this is before the letter.
Prior to the effect.
My question is after that.
Which letter? This is 26/6/2024.
Yes, your letter is of 29.
27/9/2020. Yes.
Therefore,
But
my question-
after the partnership,
So therefore, this was prior to.
this was prior to that.
So my question is after that.
No, now once they've changed it in April, after that everything
No,
got.
no, in other contract.
No, I have only one vendor code.
Here, page annexure 2.
For everything, the same bank account is linked. One vendor code, same bank account linked.
So in respect of all other contracts also.
There is only one contract, Lordship, as of now, there is only one contract. With no other contract.
What are these documents? Page
These
2.
are works of the
These
same
are
contract.
works Of the same.
So this is the contract. So there is no other contract.
Other.
So as of now, on all
Only the
contracts, we have
contract
not paid to him as a proprietor as well as also the partnership. We have not paid.
Lordship, this 467, that was paid to the original, the old account, that was before this.
I'm
was
not on
affected.
that. So my question is.
No, he's wrong.
As to this letter dated 27/9/2024. Have you made any payment to him or to the partnership?
Lordship, if there is any payment, I am not very sure about that. It is to the partnership account, because it has already been changed with effect from 12/7/2024. There is no payment as of now. There is no payment, but then a bank account attached to,
So there is no payment.
no payment.
No, now they are saying 12/7, but in their pleading, they say we have changed it in April 2024. And this is June 2024. Let the state come fairly before the court. In their pleading, they say we changed it in April. And now they say they have changed it in July. If the state is acting partisan, where do I go?
Lordship, I have already put in the.
This is a payment of June 2024, and it is in your pleading that you have changed the status in April 2024. That is their own pleading. Please come to, if I may finish. Please come to their own email, lordships. Kindly come to the reply email at page 218, 219. Sorry, 208, lordships. Please come to, may I read page 209? Please have a look at that. Please refer to your letter, lordship is at page 209. Please refer to your letter dated 22/5/2025, which letter the lordship can find it to page 204, with regard to some changes in the vendor code as claimed. In 17,
This is dated.
this is dated 4th of June. 4th of June 2025. And then it says, as claimed, as per your claim letter, nobody came to office Nazira for any changes in vendor code, nor any changes have been made. Your bank details have been changed in 2024 in the month of April, May, as per document submitted. And this is a payment of June 2024.
It has been made in your account.
Yes.
Okay. One thing, we filing the additional information as to what is the amount due to the commission, due in respect to the contract, as to whether pursuant to the changes which has happened, any payment has to be made to a different bank account or any amount paid to the petitioner. Because there is another thing, apart from that, the GST registration change also has.
Yes, lordship.
So that needs to be done something to it, because that order has to, that pass the directive in your favor. That aspect also needs to be taken, because there will be certain deduction being made in respect to that GST.
Even PAN. Even PAN. PAN has also changed.
And PAN also, no, because if they have not made the payment, then there is no problem. But if they made the payment, they have deducted an amount against a particular payment. That is, have
I
to
can
be-
tell it with confidence, let them file their affidavit. Not even a penny has gone to the partnership. Not even a penny has gone to the partnership account because the partnership account has not done even 1% of work.
No,
Let them,
no, whether
let-
it has gone or not, it's not. My question is, if amount has been deducted, because you see, this is from 2024. The problem arises is every year. The moment they must be putting it in an escrow account. And then deducting the amount as regards the tax. Now, if the tax is being deducted against somebody else, now that will have to be gone for a reversal.
that has to
So
be
that it has
reconciled.
to be paid to,
It has to be
deducted against your account. So these are things which some minor details have to be passed in that order.
And let them, and if Lordship so pleases, let them come clean whether the partnership has actually executed any work in this contract. It's a
Then-
mere assertion they are making across the
Well,
board.
Mr. Gustami, if I go into that, I'll be going deep into a civil.
Because the court should, the state, my only concern is the state should not mislead. The state should be fair. A partisan attitude for the state is not expected. They should come clean with the.
State should not be unfair, you may say. Don't bring it the word state should not mislead.
Yeah, because very well, I can take
Unfair,
back.
a person who is not unfair would not amount that misleading.
Very well, Lordship, I'll take it back, but the state should come clean with the facts.
Lordship, the whole file is before your lordship. I have given.
No, it's okay, but you file
I'll
an
file the
affidavit that pursuant to these changes which you have mentioned, they have mentioned. Have you done anything or to that effect? And if you have anything to say on this reply, because the reply has been filed today, we have it after vacation on a particular day. Now, I am in your favor, Mr. Gustami, to pass the order, but the only thing is, the only problem which I was having in passing the order is what will be the consequential direction. For Supreme Court to pass an order, they say that, okay, look out everything. Whatever it is, okay. But when we pass in a writ petition, for division bench, it is also no problem. The writ petition is the direction has to be very clear, specific, else becomes a very difficult thing for initiating a contempt proceeding.
I bow.
For the Supreme Court, no problem. They can very well say that all these formalities will be carried. Then the problem is when you file a contempt, it becomes next to impossible.
I bow down.
It is seen that pursuant to the hearing being completed, almost completed on 16/6/2026, an affidavit in reply has been filed by the petitioner, thereby enclosing various documents. It is the opinion of this court that on the basis of the affidavit filed today, without granting an opportunity to the respondents, including the private respondents, to have a say on these documents or obtain instructions in respect to these documents, it would be unfair on the part of this court to conclude the hearing. In addition to that, upon hearing the counsels, this court is of the opinion that an up-to-date status be also placed before this court as to whether any amount have been paid to the bank account which have been allegedly submitted by the petitioner relating to the partnership account. And further, as to what is the amount due to the, in respect to the work which the petitioner is presently carrying. In addition to that, there may be further update may be also placed as to whether there has been any deduction against the PAN card which have been allegedly submitted by the petitioner, as well as towards the GST registration submitted by the petitioner. An affidavit by the ONGC be filed before this court on or before 24th of July 2026. Next, the matter on 28th of July 2000.
So Lordship, consider at 2 o'clock. 28th July. I'm so good. Very good.
What has happened in this case?
Lordship, the council has filed a affidavit as per Lordship's directions. Lordship had put forward a couple of queries on 1/4/2026, Lordship. Order dated 1/4/2026.
Four. What is the basis of the sketch map of so and so? Whether the said sketch map was prepared showing the sketch of so and so village on the basis of GLT, and if so, whether there were contemporary records which would enable fixing of the GAPS coordinates. Whether the 3,000 bighas of land which have been allotted to the so and so, the part of the 2,000 bighas of land which was earlier allotted to the respondent number 7 by the officer.
We can find our exit by complying your Lordship.
You want to file reply?
Yes, Lordship.
How many replies and
Yes,
replies?
yes. Because Lordship, their affidavit shows that they did not use any GPS coordinates in making their map.
Obviously, they cannot have GPS.
Yes, at that time,
Question have been framed in this manner, so they don't have an answer on time. Because if they categorically mention it, they don't have the map or these map, they don't have it. How can they have GPS coordinates? GPS coordinates has to be made in the basis of an existing map.
yes, Lord.
This is only for the purpose of making the proceeding
Yes, Lord.
because of lack of pleading from.
Yes, Lordship. Lordship, this Lordship comes to affidavit of 24/3/25, Lordship.
Anyway, we
Yeah,
do
this-
one thing, we have it after vacation.
Lordship.
We have filed the affidavit for non. And madam, what has happened? Demarcation done, completed. Why? 3,000 because it's so big.
Plant area is done. Now, the qualification of plant and minor, that is what the maybe. But what's happening is, they have portrayed their. But then we go back. Also, probably, what we and the.
The nearby, out of vicinity to the land of the petition. You have visited there. At least this matters again on account of paucity of time, the matters could not be taken up. If this matters again on 37/2026. 30. 30. 30. I prefer Hindi. Yeah, I see some old matters, 2013 matters. Who is there? Mr. R. Islam? Matters, very old matters. Whose matters are they? RD, where is he? Old pattern matters that could not be here. RD. where is he? You can't allow these matters to go on. Yes, Mr. Architect, what is this case?
Yes, here it- they were into this casual. In the meantime, worship, they were not engaged. We went to the.
Now use your mic, use your mic. Mic is in front of you. Yes.
Yes. In the meantime, worship, they were not engaged for some time. Therefore, they went for the consent labor court. And there was a direction to reinstate them. There was a direction to reinstate them in their oath. Now, they were reinstated in service. The first case is for reinstatement. Then they were reinstated in service. The second case is for payment of the arrears. That has in the meantime been paid. The third case is lordship. In the meantime, the authorities, they issued an advertisement because the process has now changed. Now we have to go to the GEM portal, then this casual laborers have to be taken through contractors. Now that is the process. So they challenge that advertisement. So
They
that,
challenge here.
yes,
No, they challenge this one. By land. 10/3/2013. That is the document.
no, there
Yeah.
are four cases together. I'm just giving the sequence first.
Okay, 10/3/2013 is information regarding employment of daily wages in compliance with so and so. As per the load to be handled and requirement labor on daily casual basis, but before there is a need to engage casual employees only for maximum of a month. We are requested to kindly report for work as per the aforementioned schedule. This is state.
Yes.
Now, what is the effect of this state?
Now what has happened, Lordship, is after this order, we have, in the meantime, Lordship, the contractor has also been appointed. We have asked them to report. They have themselves not come to work. We have asked them to report. Now, we have also had a discussion with the contractor that you keep these people. Because now we cannot keep casual laborers. We have to keep them only through the contractors. So we have,
As per the contract regulation.
yes. Now, they do not report for duty. The position as of now is they have not reported for duty. We have sent people asking them to come. They have not come for their duties. But we have also asked the contractor.
That means 10/3. Now let us see the second part, second case.
Lordship is
2013, the next case is, what is the case here? The second repetition is the sick prisoner who were working and they were terminated from the engagement. Against the industrial issue was raised so and so, challenge is so and so. SLP was reinstated and was not complied with, it filed contempt. Petitioners are now agreed by the Mumbai for recruitment of Mazdoor.
now they wanted to get them.
Engagement shall not be disturbed. So there is no, your engagement with the petitioner should not be disturbed. This is another order
This is another one.
by which you continue whether they work or not.
Yes,
Because this interim order is a very dangerous interim order.
that is one.
Huh?
That is one.
Means by the age, you keep them paying, but if they don't come also, it is finished. You keep on paying. This is the second. Very dangerous. Number 3 is issue notice returnable here. Now, what is the third repetition? So the petitioner submitted a detailed report, they are authorities on demand paying for payment of arrears beyond demand for every month from the period of the arrear till demand. The respondents have not served it by letter inform the petitioner the payment of salary beyond demand cannot be exceeded.
They are our requirements. Since the payments have to be again released from Delhi, the process was, in the meantime, it has been released. In the meantime, it has been released.
Released. So this payment you have made.
Yes.
earlier part.
Yes.
Now subsequently,
Subsequently, Lordship, they have to come to vote first.
they are not coming. But you are not in a position to disturb them. So in fact, the 2804 has become success.
Lordship, in my view, Lordship is.
Here is again another one. Issue. What is this? This is contempt case.
Contempt is, Lordship, they make an allegation that we have not allowed them to work.
Ah.
Now, you have to report for duty. My reply is, Lordship,
You have filed an affidavit.
I have filed an affidavit on behalf of.
You have filed by someone's. So they have not started only from 1/5/2024.
Yes, after the contract.
But it is 2023. And 13.
The previous one was, Lordship, pursuant to the award. They say that they were not reinstated in service in our, but subsequently we have. Then the question of backwages came. That also, it took some time, but that was cleared again. Now, in the meantime, they challenged the advertisement by which we could call for contractors. Because now
That has been challenged.
that has been challenged.
Their only order is that they should their here should not be engagement should not be disturbed.
Now, their contention was, Lordship will appreciate their casual employees. Now, there is a cadre, schedule of regular Mazdoor, that their claim is that they should be absorbed as regular Mazdoors. Regular Mazdoors,
Is there a prayer to effect for regularization?
they did make it. They did,
What happened?
no, Lordship, they have to participate. We have issued an
So
advertisement.
what do you say about the recent judgments? Is it dangerous? Now the contempt is here. You categorically say here to the effect that however, they have not reported to the depot from the start of the contract.
Yes.
You denied that even I have restrained the commissioner and two others from working as Muslims. Now, how are they working if you are already having it done through the contractor?
My stand here in the by instruction, we have tied up with the contractor. We say that the contractor will engage these people because they are casual. They are casual. So it will be only need based.
So their engagement is still intact.
On papers, yes. But they are not reported.
To do one thing, you file an affidavit in this thing, given an updated status in all the code, all the three would put, along with the content is no problem, but in the three would put, three enough.
There are four.
One is for these, second is these, third is this, and fourth. All these four equations given update by filing an affidavit. What is the presence? What is the going? What is the problem? Present status. Because these are of 2013.
Yeah, sure.
We give an update on that so that we are in a position to take it. Because 2013, the problem is at that point of time, they say that the first petition comes about 10/1/2013. That has been stayed. In fact, the stay means what? They will be working for 30 days. Not understood. Second is some payments have not been made, which you say the payments have been made. You put an update to them. Third is they say that there is a Mazdoor to be selected. So the court passes an order, do whatever you feel like, but don't disturb them. This is third. Then the fourth is what? Fourth is the contempt. No, another petition.
It's a 2804.
Naresh Rai. What are they asking?
Clear.
So these are the three, no? 1, 2, and 3,
No, no.
15. I don't know, another one. 213. So you give an update.
Flush.
Okay. And we'll take it up as regards the contempt. Contempt, I think, we can't, at present, are they voting and all, give an update. What is the present state? Yeah. None had appeared on behalf of the petitioner involved. Mr. Architect Chaudhary, the learned senior counsel, as well as the DYSGR, appears on behalf of the respondents, assisted by so and so. The present batch of petition, along with the contempt, have been pending since more than a decade. Under such circumstances, this court heard the lead petition. From a perusal of the instant petition, the batch of petition, the records of the batch of petitions, it appears that there are various interim orders whereby certain communications have been stayed. The engagement of the petitioners have been protected. As well as questions have been raised on account of non-payment of the dues of the petitioners. This court also takes note of the recent contempt series, the recent contempt petition which has been filed, wherein it is the case of the petitioners that their order passed by this court came. Order dated 26/2013, passed in the application number 3379 of the 2013 have not been complied with. On the other hand, the sole respondents have categorically mentioned that their petitioners have been duly paid their dues. But after 1/5/2024, they have not reported to the depot for their work. And as such, the question of payment to the petitioner will not arise. Taking into account the above, it is the opinion of this court that an affidavit, a detailed affidavit, be filed by the respondent authorities giving an updated status as regards the stand of the respondents who are the present proceeding, who are the four petitions, who are the four petitions. So that the same may aid in disposal of the same. When
Can it be on 16th of July?
you can file it.
Should be.
Huh? This matters again on 16th of July 2026 at 2 p.m. for final disposal, showing it as partnered. 16th or 23rd?
Worship. Then that will be in the service admission.
Huh?
The last week. Then
Okay, and the way old matter look to them.
let it be on 10th of August. 10th of August.
10th, no, 11th.
Oh.
On 11th at 2 p.m. The affidavit we filed on the before 3rd of August. File your affidavit by 3rd of August.